I would like to mention item number 19 and 39. I'm in proxy counsel. The engaged counsel is ill. That's why 1 week time may be provided to us. I have from the
19
and 39.
19, you want to mention it. What is the matter about?
Pardon me?
What is the matter about?
No, I'm not the engaged counsel. I'm a proxy counsel. The engaged counsel is my friend, and he has intimated me to form this board for this. He is ill, so I'm an.
Is there an interim order? Don't mention it. We'll see when the matter is. About 39, you are the counsel? No.
No, yeah, I'm not the counsel. I'm the.
So this we can adjourn it. 39, this is the matter after 2 weeks.
Deeply applies. Wait, please, Lord. Now I make comments at number 13. The matter has become infructuous, my friend. My instruction is not to pay the writ petition.
The RM Decca, the learned counsel appearing on behalf of the petitioners, submits that the writ petition has become infructuous. Accordingly, he submits that the writ petition may be closed. Mr. B. Sharma appears on behalf of the railways. To account the above, the instant writ petition stands closed as it has become infructuous. Interim orders, if any, stands vacant.
Wait, please, Lordship. My lord, I'm praying for your lordship indulgence in allowing us for posting of an untested, my lord. Oh, new writ petitions we have filed yesterday. There's some urgency involved pertaining to, my lord, this matter. It relates to, my lord, settlement of fishery.
You want to do the matter today?
Or tomorrow, my lord. It's not inconvenient for
Not tomorrow, today.
Yeah, my lord, 2 o'clock.
Yes, two.
I'm obliged.
But we have given an adjournment slip yesterday regarding item number 21, my lord. My lord, the difficulty is that, my lord, there is a communication gap with our client. We could not take any instruction, my lord. We've taken the consent of the state respondents, my lord.
Are you enjoying a stay?
No, my lord.
Lordship, there is an interim.
No.
Observation. There is an observation. There is no interim
What
order.
observation is that?
Not to take any coercive action, my lord.
That is an interim order. We vacate the interim order.
My lord, may I allow?
Once it is vacated, that the client will rush to you.
My lord, this is a genuine submission, my lord, will allow.
No,
us
no,
to
that
reach
is why you have not been able to contact him.
my lord.
Very well. Once it is vacated, he will know what are the consequences is.
Pardon us for today, my lord.
No,
To take up this matter, my lord.
absolutely no. I'm not going to extend the interim order then.
My lord may not vacate, my lord take up the matter. Otherwise also, my lord, we have to file our reply because the state respondents have filed their affidavit in opposition. We have to file our reply. But without instruction, it's difficult for me to make this submission, my lord.
So, what do you want to do?
My lord may grant us 1 week time at least, my lord. 1 week.
Your name?
And Ashok Burman, my lord.
Mr. N. Burman, the learned counsel appearing on behalf of the petitioner, submits that he requires 1 week's time for filing the affidavit in reply to list the matter after 1 week.
I'm deeply obliged, my lord.
We fix a date on 31st of July.
Much obliged.
Mr. DJ Das appears on behalf of the respondent numbers 1 to 4, and Mr. D. Gogoi appears for the Forest Department.
I beg to item 9, madam.
Yes. Mr. Gogoi, he asks for 1 week's time for filing the reply. Item 21.
Item number 9, madam. But if personal hesitation is concerned, madam, their committee has been changed, we could not contact with them. So, madam, 2 weeks time will be granted to obtain instruction to them. 17 matter, madam. Non-payment of contractual is a matter.
Non-payment, if it is there, will direct payment. Then why you are asking for adjournment on these matters?
We have to file regional affidavit. They have filed an affidavit in opposition.
What do they say?
No, nothing.
Then very well, you should get an order. Don't mention. Next.
40 lordship, 1 I,
40. Yes.
It may be called for lordship. It may be called for with the responsibility.
What have you filed?
A lordship for implement or substitution of contempt's lordship. Incumbent's lordship.
Item number 40.
40 lordship.
Okay. You have filed an IA. So IA, I can't call for it. Miss So-and-so appearing on behalf of the petitioner
Yes, lordship.
submits that an interlocutory application has been filed in the instant matter. List the matter again on 31st of July 2024 along with the interlocutory application.
Yeah,
Let legal lordship. I briefly mentioned item number 25 lordship. And if it is in opposition to the file, file reply.
You mention all these things when the matter is taken up. Don't make all these things.
It legal lordship. We concept from the address and document item number 10 of today's my lord. My seniorities some difficulties lordship may be taken up in next week.
2019 matter.
The next week anything.
You are enjoying an interim. Huh?
Yes.
No, we vacate the interim. You take your time whenever your senior is available. Don't come up with all these prayers. Next. 2019 matter, 5 years have gone. Bench 4. Okay.
Legal lordship. I just mentioned item number 11 is the consent of the opposite party, madam. If the sitting of our office, my lord, telephone record is not rest.
I take my record. Take my second record. Don't make her mention all these things.
I wish to mention for listing of the WPC lordship.
Huh?
WPC lordship. As listed on 1 to 24 lord.
Okay. Let it be listed on 2nd of August.
I'd like to mention item number 42, it's contempt is my learned friend is appearing. So there is another contempt. In that case, there is order to take with this contempt case number 420 in 2023. May pray my lord that this matter will take up with that matter. 421.
Item number
42.
42. Mr. P. Hazarika, the learned counsel appearing on behalf of the petitioner, submits that there is another analogous contempt matter being contempt case number 420/2020.
421.
420.
421.
421 of 2023.
20.
Full stop. He therefore submits that both the matters be taken up together on 31st of July. List the matter accordingly. List both the matters accordingly.
Okay. On promotion.
What is this? Non-payment of dues.
Non-payment of which this is
Who is to pay?
SDRF, that is Revenue Department, Deputy Commissioner of the concerned district.
Revenue? Revenue is not there. No revenue council. Yes.
Revenue has not been implemented, Lordship. Only DC has been implemented. Deputy Commissioner in the last order.
Where is the contract?
Lordship,
Who has given the work order?
work order, Lordship. Work order has been given by Water Resource Department.
Then?
Executive Engineer. Lordship, this,
Then why you are making bringing in the revenue out here?
no, Lordship, this is the scheme under SDRF, State Disaster Relief Fund Scheme. That is under the Revenue Department. Actually, the concerned Deputy Commissioner of the district used to make the payment for this, Lordship.
So the deputy commissioner is already there. Then
Deputy Commissioner is there.
why do you need the revenue then? Make verification and pay.
Lordship, we are only the executing authority.
Very good. Whoever it is, who is it? The deputy
Deputy
commissioner. You have to pay. Make the verification and pay. Unnecessary matters should not be there.
Name has not also been shown of the government advocate.
Huh?
The policies we have not shown, my lord. Name, our name has not been shown. But yes,
Problem arises because there was no direction. Filing of an amended cost title within 1 week. Has it been done? No amended cost title filed.
Right, my lord.
To do. Petitioner counsel is not there. None appears on behalf of the petitioner on call. It is further seen that there was a specific direction passed on 14/8/2023 as well as on 22/9/2023 for filing a fresh memo of parties. However, the office note dated 11/7/2009-24 shows that no such memo of parties have been filed. Accordingly, this court for the ends of justice adjourns the matter to be listed again on 2nd of August 2024. It is made clear that if the petitioner does not file the fresh memo of parties within that said period and is not represented on the next date, the instance writ petition, it shall be construed that the petitioner is no longer interested in the matter and accordingly appropriate orders will be passed. Yes.
And that is the order for amendment the cost title basement. I am not
Either
understood what
response
is
number
the
5 tender
amendment,
is
the
not
cost
stayed
title,
and you can
What
not
is,
given opportunity for.
the
Huh?
effect, my lord.
What? Retender has been done. PWD. There, the PWD council.
And the petitioner, my lord. And the behalf of petitioner, my lord.
Understood. PWD is not there.
Department of Housing and Urban Affairs has taken
Which department?
municipal court and the member secretary Polasari. Because I petitioner is a businessman, he submitted tender for requirement of Department of Housing and Urban Affairs as technical staff. Subsequently, my lord, one board was constructed, and in the board member is the member secretary Polasari Municipal Board, Circle Officer Polasari Circle, Department of Housing and Urban Affairs as technical. And tender was passed in favor of Odil Thakuria, respondent number 5. Some they have not given opportunity the petitioner, my lord, for in the meeting, my lord. And subsequently, tender was passed in against respondent number 5. The grievances, my lord. The proper verification, respondent number 5 tender was passed in court, my lord.
Madam, you withdraw this petition. Absolutely. How is this petition maintainable? The state of Assam is represented by the chairman, Polasbari Municipal Board.
I can
My
see that,
goodness.
my lord,
Then the member secretary of Polasbari Municipal Board, Circle Officer Polasbari, Department of Housing and their FIS Technical Cell. What is this?
yeah,
File it properly.
no, I have an amendment, kindly, matter may be fixed on this day, my lord.
No. You were given an opportunity on 21/12/2023. You have not done. 6 months, 7 months have passed by. Withdraw and file a fresh one. The learned counsel appear.
I am constituted this is amendment at 2 p.m. my lord. Matter is taken at 2 p.m. my lord.
Why?
I have amendment the page, my lord. Title, the cost title page, my lord.
Post title. You have to entirely change everything. You can't make it like this. The state of Assam represented by the chairman. And this opportunity was given to you in the month of December 2023 when the weather was cold. Now we are in the heat.
Then
Withdraw and file a fresh one. You want to file a fresh one or should I dismiss it?
Divided to withdraw, my lord.
Withdraw, well, file a fresh one.
I kindly matter may be taken at 2 p.m. I am already first title page is amendment, my lord. Today.
No, madam, nothing doing like that. You cannot amend it by hand, and it is done by hand.
Paragraph 10 also, my lord, paragraph 10.
My
How she can
goodness.
amend lordship? Paragraph
The
10.
petitioner prayed before the court accept this writ. This writ petitioner state the accepted tender of the
As per the
Give a direction to respond number 1 to 4 also.
huh?
Give a direction to respond number 1 to 4 also. If she amended the cost title also, it cannot be 1 to 4 also. Because lossy 1 cannot be represented by the police by municipal board.
The learned counsel appearing on behalf of the petitioner submits that she may be permitted to withdraw the instant writ petition and given a liberty to refile, taking into account that there are formal defects in arraying the parties. So taking into account the above, the instant writ petition stands closed and liberty is granted to the petitioner to refile by removing the formal defects. Mr. K. Gogoi appears on behalf of the state.
Please, Your Lordship. In this case, Your Lordship, I have to file an
What?
additional affidavit.
Why?
Lordship, another two documents.
What is your case? Should not be issued by setting aside and quashing the impugned letter dated nil and subsequent orders issued by the respondent as to why she have. What has happened out here, madam? Huh? Tender notice was issued. 1/6/2024. Then what happened?
And impugned order was passed on 12/6/2024.
Page, annexure 4. Where is that annexure 4?
Last 30 page 35.
In pursuance to the order passed by the executive officer. What is this appointment?
My lord, actually, this is not settlement, my lord, because the petitioner is trying to establish that tax collector settled the ghat with the private respondent. But that was not, my lord. Page 34 was an authorized letter, my lord, by which the tax collector of the government, my lord, just authorized one person to collect on behalf of the department. And this is signed in the year 2023.
And
Therefore, my
does
lord,
no, I don't understand. Does the tax collector have the power to delegate?
delegate, it's just, my lord, to collect the
No, does he have the power? Is it
now,
you?
my lord, that has become infractions, my lord. Because now, my lord, this particular ghat was notified by the IWT, my lord, as a government ghat, my lord, and the petitioner himself filed one petition, my lord, that the IWT issued NIT and settled this ghat with another one, my lord. Thereafter, petitioner filed an petition which has been disposed of, and in that case, my lord, IWT, my lord, stated, my lord, that the ghat will be removed from that place, my lord, from the petitioner's land, my lord. At present, we are not running.
Understood, whatever may be. I'm not concerned with that. But does the tax collector has a power to delegate?
That is not exactly delegation, my lord.
No, see,
That's authorization, my lord.
no, to collect toll so and so per foreign on my behalf.
Because what
Who is
my
the
lord,
tax collector?
practically,
How is the tax collector
in a Gaon
appointed?
Panchayat, only one tax collector post is there, my lord. But there are different ghats and markets are there.
Huh.
So so to maintain the discipline, my lord, they just authorized to collect only, my lord. But now we are not running, my lord. This one notification is already there, and also video also. So technically, this petition become infructuous, my lord.
So as per this notification, what happens?
This lordship may kindly peruse the next page, my lord. Order 8/2/24. The chief executive officer directed the video, my lord, to hand over the card, my lord. And practically, they already
So now it is under the inland water
IWT.
IWT. This is not no longer under the you are for the PNRD.
The PNRD.
It is no longer under the PNRD.
Yes. My submission can be recorded, my lord.
Keep,
No, but I don't understand what is this. And he who was given Atawar Rahman was given to Black so and so. We have authorized Saidul Islam. Who is Saidul Islam? Saidul Islam collects Sutapa Iha Parghat for the instant repetition has been filed by the petitioner, being aggrieved by the issuance of a communication issued by the tax collector, dated, what is the date?
It is not there.
Issuance of a tax collector, issuance of a communication dated by the tax collector, /RM, Ozaikota, Kuapata, GP, whereby the petitioners was debarred from collecting taxes for and on behalf of the tax collector, and one Mannat Ali was permitted to do so with effect from 12/6/2024. Mr. S. Dutta, the learned counsel appearing on behalf of the PNRD department, submits that the said ferryghat, being Swapata Part Roman 3, no longer is under the jurisdiction and authority of the PNRD department, and it has been transferred and it has been declared by the notification dated 15/12/2023 by the issued by the Secretary to the Government of Assam Transport Department to come within the ambit of the inland water transport Assam. He further placed on record the notification dated 15/12/2023, as well as also a communication issued by the Chief Executive Officer of the Jila Parishad Dhubri dated 8/2/2024, wherein there was a direction issued to the BDO cum Executive Officer of the IERALGA, Anchalik Panchayat, to hand over the said ferryghat to the Assistant Executive Engineer of the Inland Water Transport Subdivision, Dhubri. Full. The said communications are kept on record and marked with the letter X and Y. On the basis of the above, the learned counsel, standing counsel for the PNRD submits that the instant writ petition has become infructuous. This court, upon taking into consideration that the PNRD department has no longer any authority over the said Swapata Part Roman 3 ferry service, the impugned order by which the petitioner have been debarred by the tax collector has become redundant, and as such, inasmuch as it is now the Inland Water Transport Department of the Government of Assam who controls the ferryghat. Under such circumstances, nothing further remains to be decided in the instant petition for which the same stands closed. Or
Every lordship. Lordship, in this case, what has happened is there are now three tenders. The first tender was issued on 14/3/24, that was cancelled. Another tender came up on 15/6/24, that was cancelled. Now the third tender has come up on 8/7/24. We are aggrieved by the fact the clauses which has been incorporated in this third NIT dated 8/7/24 are in violation of the Assam Public Procurement Act 2017. Assam Procurement Act Public Act 2017 does not distinguish between the bidders. Now, what has been sought to done is that distinguish.
yesterday I issued a
Yes,
notice. Did you participate?
WBC
Go and participate. Today is the last date. Go and participate. Issue notice. We'll make it subject to outcome of the petition.
They may not open the financial. They may not open the financial.
Absolutely no. We'll look into it later on. Your basic case is that about clause 7 and 21.
We have challenged clauses 3, 4, 8, 9, 16 and 21.
The different clauses.
3, 4, 8, 16,
Have to
3, 4, 8,
upload.
9, 16 and 21.
Why you are challenging 3?
Lordship, 3. Lordship, in clause 3, what has been said is that the bidder shall have to upload the copy of the solvency certificate received from the bank along with a copy of the authentic transaction statement for last 1 year. The bidder should not be a defaulting in paying banking dues. Lordship, this clause was earlier also in 14/3/24 and 15/6/24. But this part, it is not applicable in respect of GPSS, WCCS in their own. But bank certificates should be submitted by GPSS, WCCS. This part has been brought in. No, it is not. It has been brought in for the first time in this tender.
Defaulting.
Lordship, defaulting. Now, Lordship, regarding the defaulting point, if your Lordship takes up the Assam Public Procurement Act.
Are you running
Yes.
presently?
Yes.
Very well. Done.
Lordship will just take up page.
You submit your tender. No, nothing.
Lordship, just look into the clause for a minute. Lordship. Page 1032. Lordship, at the top. Well, this is one of the criteria laid down under the Assam Procurement Act. Lordship will take up clause 5, subsection B, 1.
This is done under NFSA,
Lordship, but it is a public procurement and it is bound by this.
not under the NFSA.
It is under the NFSA. The scheme is under the NFSA.
Then?
But when the state government issues a tender, it
Have you
should be-
challenged the cabinet decision? Then
Because cabinet decision is not harming me in any manner. Lordship.
cabinet decision categorically mentions that there will be preferential
There will be
treatment being
preferential
given to the GPS.
Differential treatment provided they fulfill the terms and conditions.
Yes.
Because Lordship, this condition we have challenged on the ground because see, Lordship, it has been stated in 5, clause 6, subclause 5, subclause B. Any bidder participating in the procurement process shall have fulfilled this obligation. Lordship, at page 1032 on the top.
10?
103. It's written on the top note, on the top left. Page numbers are given.
106,
Of the gazetted notification.
E2. Yes,
Lordship, clause 5, it is clause 6, subclause 5, clause B. 1. Any bidder participating in the procurement process shall have fulfilled his obligation to pay such taxes payable to the central government or the state government or any local authority as may be specified in the bidding document, prerequisite qualifications or bidder registration documents, not to be an insolvent, in receivership, bankrupt, or being hold up, not have its affairs administered by a court or judicial officer, not have its business activity suspended, and must not be subject of legal proceeding for any foregoing reason. That is why, Lordship, that requirement was necessary even for the GPSs and the WCCS. Now they have given a waiver. And similar tenders have been issued in other districts. There are no such benefits given to the GPSs and WCS.
hey, LF check. Security. নতুন নাই নেকি 5 বছর হল নাই নেকি
So if your lordship comes to clause number 8 of the bid document,
Is there any rules made under this act?
there are rules, lordship.
What are the rules?
The rule of 2020, same, some public procurement rules 2020.
Page?
So that is not. I have checked it. I didn't find anything. I have checked the rules. Lordship, I have not found any provision which correlates to this case, so I have not got it. Lordship, I will submit clause 8 of the bid document. Lordship, 8 says the bidder should have GST registration and upload copy of the up-to-date clearance certificate from the sales.
Which
department.
one? What you are
Clause
reading?
8 of the tender, of the impugned tender at page 48.
Would have GST registration and upload the copy of the up-to-date clearance certificate.
The sales department. This was in the earlier tenders also. The other part, however, it is not applicable in case respect of GPSS and WCS. It never found the place either in the tender notice dated 14/3/24 or 15/6/24. This has been brought in for the first time. And this is again in violation of the clause I've read. Clause 6, sub clause 5, B. Have fulfilled all his obligation to pay such taxes applicable to central government or the state government or any other local authority.
What is 5A?
5A says the procuring entity may lay down reasonable eligibility condition for participation.
Where is 5A?
Lordship,
Subsection 5A.
5A is at
Oh,
page
5A.
1032.
Procurement may, however, lay down reasonable eligibility conditions for persons existing from and in addition to any technical or limitation.
The lordship, if the lordship sees the definition of bidder, bidder means any person that is under 2A, subsection, clause 2, subsection, section 2, subclause B. Bidder means any person, company, firm, agency, institution, etc. participating in a procurement process of a procuring entity for procurements of goods, works, or services. And lordship, clause 7(4) clearly states any requirement established pursuant to section 6 and 7 shall be set out in the pre-qualification documents or bidder registration documents, if any, and in the bidding documents shall apply equally to all the bidders. So all the bidders have been put in the same pedestal. What they are trying to do is give an undue benefit to the GPSS and the WCCS, and thereby removing the level playing field at all. Your lordship takes up page 1033, qualification to bidder, clause 7, and the next page has clause 4. At 1034.
So you are challenging which clauses?
challenging clause 3, clause 4, clause 8, clause 9, clause 16, and clause 21.
So here a bidder is required under 30 vehicles and GPS is only 4.
Yes, sir.
Now, is
For
it the
bidders like
reason
us, we
why?
have to give 30 vehicles, and for GPSs, they are saying only 4 vehicles is sufficient, considering
Finally come to number 7, clause 7.
lordship.
The bidder should bid for 21 numbers of GPSs in both Tier 1 and of the Hojai district. No partial rate quoted shall be accepted. Quoted rate shall not exceed ceiling of admissible amount of rupees 136 per quintal, taking both Tier 1 and Tier 2. The secretary of the GPSs and so may quote bid in respect to their own along with tag if any. So isn't it because they have to quote, they need not quote for all the
No,
21?
lordship. As per my understanding, lordship, even a GPSs has to quote for 21 numbers of Tier 1 and Tier 2.
No, why
may
is
quote
this
for
line
both.
then? The secretary of the GPSs may quote bid in respect to their own,
Along with tag.
along with tag if any.
Yes, lordship. So he has to quote for Tier 1 and Tier 2. In that, he can include his own GPS along with GPSs, along with the other GPSs. Tag with
Now, how many locations are there?
lordship, 21 we have to give in any manner.
No,
For
you
Tier
see,
1 and
no.
Tier 2.
A bidder should quote bid for 21 numbers of GPSs. But a secretary only quotes for only one of his, and if there is any other tagged GPSs,
Lordship.
not others.
Lordship, in fact, as I can see from the bid document, lordship, there are 21 numbers under Tier 1.
No, we are not concerned with that. You see, it is made very clear by clause 7
Yes.
that he has to only quote. Normally, a bidder has to quote for 21 numbers of GPSs. But a secretary of a GPS would only quote for his GPS. And if any other GPS has been tagged with that GPS.
So I am not challenging this clause. So even
No, this has a relation with that other one. That is why he requires only 4. Compared to 30. You see, here he has to give for 21. But here the GPS secretary has only to give for 1. Or any other tag, if any.
Your lordship reads clause 21 of the render notice. It may say a bit differently, lordship.
The rate will be compared on the basis of aggregating average rate quoted so and so by the bidder. In case of here, L1 rate will be considered individually.
That means, lordship, for Tier 1, if I being a tenderer, quote for Tier 1 rupees 50, because 130 is the limit. I cannot go beyond 130. I quote
136.
136. I quote 100 rupees for Tier 1, 100 rupees for Tier 2. That 100 rupees plus the 100 rupees into 21 will again be calculated and the average will be found out. That will be my rate. However, in case of GPSs, if they quote 70 for 1, that itself is accepted. There is
No, that will be considered that, you see, the secretary will quote for his.
But if he quotes for the others also, it is the clause says he may. So he can go for Tier 1 and Tier 2 also.
Bid in respect to their own, along with tag,
He's saying
if
may
any. So here he need not quote for 21.
He may not. If
He may
goes,
quote only for 1.
But if he goes, then I will do that.
Then what happens? If you are then, just for example, a secretary has quoted 80 rupees of the GPS of that.
That along with
Whereas a bidder who has quoted for 21, his is L1 is 70. Then he will get for 70. The bidder will get it, not the secretary of the GPS, although he has only quoted for that. Therefore, if you read 7 with 21 and read it with 16. That is the meaning.
But the other clauses are there. It's
But
valid.
the other clauses also has to be touched on that aspect.
Lordship, because that is sales tax certificate at clause 8. Is
Where?
defaulting at clause 3.
Clause
Clause 3 says about defaulter. It says it is not applicable for
is not
GPSS.
applicable in the area, but bank certificate
bank
should be submitted by
bank
the
certificate
GPSS.
Does not say about
What is the bank certificate?
defaulting certificate. It may be any certificate, Lordship. It is not clear in the tender itself. What certificate? They can simply say, I have an account in this bank. That itself is a certificate. And Lordship clause 8, it says about the up-to-date clearance certificate from the sales tax department. However, it is not applicable for GPSS, WCCS. It is not in the earlier tender. It has been brought in this tender. And these clauses do not find place in any other tender district for the other districts of Assam.
No, you see, number 4, the bidder should have
Yes.
to upload the
Yes.
PAN card, GST along with income tax return for the last 3 years because you are a new one.
Huh.
You are not there in the scene.
The income tax
Whereas
return is not
income
applicable in
tax
case of
return
GPSS
is
and
not
WCCS.
applicable in case of so and so, but he has to give the PAN and the GST.
Lordship, but this thing along with income tax return, it cannot be waived off for the GPSS in such a manner.
Huh?
GPSS also pay income tax.
Whatever may be, how does it make a difference with you? As regards the income tax return given or not, how does it make a difference? How does it violate you with your tender?
Lordship, this clause B, clause 6, section 6, clause 5, clause B says that he has to pay the taxes applicable by the central government.
That is
and state
why he is
government.
going to pay it. Income tax is different. Return is different from taxes payable. He has to give his PAN card. He has to give his GST.
Yes.
So he has to give his GST and his PAN card. That he is going to give it. Now, as regards the other, the bidder should also not be a defaulting in payment. It is not applicable in their own. Only 3, the bidder shall have to upload the copy of the solvency certificate received from the bank along with a copy of the authenticated bank's transaction for the last 1 year. The bidder should not be a defaulting by paying banking dues. It is not applicable in respect of GPSS in their own, but bank certificate so and so. So, in the case of a defaulting, you mean to say GPSS is exempted.
Yes, the clause itself says.
That is not there also. It says that my lord may kindly peruse. The bidder shall have to upload the copy of the solvency certificate received from the bank, along with the copy of the authentic bank transaction statement for at least 1 year. The bidder should not be defaulting in paying bank dues. Then lordship says it is not applicable in respect of their GPSS and WSS in their own. But bank certificate should be submitted by the GPS WSS. They should be submitted the bank certificate.
Understood. But does cannot the GPSS be a defaulter?
No, they cannot. The defaulter we cannot accept, lordship.
Then why you are not making
they have
specific
to,
there?
the language is not very clear. Otherwise, the meaning is that, lordship, there should be a bank certificate submitted by the.
No, tomorrow GPSS may very well come up and say he is the defaulter, he will submit. And a reading of class 3 shows that defaulting GPSS would be permissible.
Defaulting is not permissible because they have to submit the bank transaction certificate also.
What bank
It is also given waiver for
A bank certificate.
They have to submit the bank certificate. Bank certificate means loss.
What is a bank certificate?
Bank certificate means there should be an account. They have the continuously. There should be a transaction is there. They are not defaulter. That is the bank certificate.
How can he say? The bank, State Bank of India will say that this DPS is not a defaulter in payment of dues to the government.
That government part, no, I am saying on in respect of the bank loss. How they are sound or not loss.
He may not be a defaulter with the bank, but here you are putting should not be a defaulting in paying the banking dues.
Paying the banking dues loss. Paying the banking dues loss.
So this bank certificate of the GPSS should mean this, that he is also not a defaulter.
Loss. In respect of banking dues loss.
I may submit lordship, solvency certificate.
Now,
is something different.
you
Solvency
say you have
certificate is
challenged 8, 4 and 8.
If I submit against three lordship first, solvency certificate is a certificate issued by a bank saying that a particular person or an individual or an entity is solvent to the extent of X amount of money. Quite clear. A defaulter certificate would be something. If I fail in depositing one EMI of a loan which I have taken, I am a defaulter. So that is why the defaulter clause is there separately for the TPS. Lordship,
How does it affect your bid?
does not affect my bid,
Then,
lordship.
no,
TPS
if you are not,
see,
then what is the
Ineligible
locus to
bidders-
challenge that?
Our entire case is that by relaxing these clauses for the GPSs and the WCCS, we are trying to make eligible the bidders who were earlier not eligible under the earlier two tender. That is our case. That is why this relaxation has been given. In fact, lordship, the second tender, which was cancelled, if your lordship will take up the minutes of the second tender.
The second tender minus says, kindly come to 15.6, page 39.
Page 39, lordship. Page 39 is the second tender, lordship. Lordship, there is a minute.
No, the minutes I've seen it yesterday.
Yes.
You are mentioning about the last paragraph.
Page 45, yes.
The last paragraph, that there were some
There were
technical
some
errors.
technical and clerical errors.
Clerical. Oh, it's okay. Now kindly come to number 3.
Number 3, yes.
Earlier, the bidder shall have to upload the copy of the solvency certificate earlier. Received from the bank along with a copy of the authentic banking transaction statement for last 1 year. The bidder shall not be a defaulting in paying the banking
It
dues.
stops at here.
Now they have added that for GPSs, they will only give a bank certificate.
They are saying that it's not
How does
required
it,
of the-
how does it affect you
Because lordship,
from submitting a bid?
as I was saying, lordship, WCCS or a GPSS, which has already defaulted, he was rendered ineligible under the earlier tender. Now by bringing this clause, those bidders have been made eligible. That is our entire case.
So how does it make it, how does it affect your tender?
It affects me because now, lordship, those bidders who were earlier ineligible, they will come into the scene. And then the competition will increase furthermore.
So
Because they were earlier.
on the other hand, you are relying on this,
Yes.
which says that there should be more competition.
No, lordship. It
Yes.
says that the rules have to be fulfilled, lordship.
No, kindly
That-
come to this clause 5.
Lordship, but that does not.
No,
enforce
no,
the
no.
Clause 6.
On one hand, you say this, the here is kindly see number 6.
The procuring and eligibility.
Shall not
entity may,
establish
however,
any
be-
requirement aimed at limiting participation of the bidders in the procurement that discriminates against amongst the bidders or against any guy except where authorized or required to do so by this act or the rules or the guidelines made thereunder or by the provisions of so and so. So you want more participation.
Clause 7(4).
On one hand, you want this.
7(4) says, any requirement established pursuant to section 6 and 7 shall be set out in the pre-qualification document or bidder registration documents, if any, and in the bidding documents, and shall apply equally to all the bidders. So what is for me is to be for them. So what is given to them should be given to me. That way also
They
they
have
can
to
increase the
challenge lordship
participation.
the cabinet days.
Lordship,
In
that,
that respect, they have to challenge the cabinet days.
That is why 30/10/2021.
Lordship. They have to challenge the.
Without challenging that, how do you escape the provision? There is the biggest problem is there.
but lordship, that cannot override the statute. Just it says that it shall equally apply to all the bidders. If they want to increase the participation, let them relax the clauses for all the bidders. More bidders can come in that way.
Which condition?
The other the condition.
That there
which we
should
have
not
challenged,
be, that you should not be defaulting.
let them relax
Are
it
you a
for everyone.
defaulter?
No.
Then how are you concerned?
Main intention behind filing this petition is lordship, they have to run the lordship.
No.
That is the reason. Otherwise, no reason
Submit.
is, no reason is there lordship.
Bid,
Let them at
you
least-
have,
no
you have,
reason is
you have
there, Lord.
till time to the submit.
I'm sorry, Lord.
No reason is-
I am
Let them at
fixing,
least not open the financial
no,
document.
nothing
Only
doing.
No reason is
I
there.
am fixing, I fixed the matter on 5, na? 5th,
Lordship,
okay. You file your affidavits in this regard,
lordship will fight.
and yeah, we'll take a call and we'll make it subject to the outcome. We'll set aside if need.
Otherwise, he make a submission that
After
he is
10
not
days for
running,
1 year.
continuing the transaction.
Lordship,
Lordship,
for 1 year, if you open the financial bill and start with the process. he will go with.
Otherwise, they will on the extension
That
for
is,
lordship.
that is only.
They will on
process
extension
that-
lordship.
Lordship
Nothing is
can
their
continue
lordship.
with- let them
Their
proceed with
main
the tender.
purpose
Not to
is to
finalize the
lordship
tender.
continue the handling process lordship.
Lordship, let them proceed with
Handling
the
and
tender, but this is
transportation
not
process
finalized. Let them
lordship.
devote this lordship.
Without lordship, the competition lordship.
Solid that much.
The main
Till
reason
fifth.
behind this lordship.
Till fifth.
Main reason behind
It doesn't affect you. It does not affect you. I would have understood if it had affected. It doesn't affect you. Are you a defaulter? Then how does it matter?
Lordship, the issue is competition increases.
Only reason is that lordship.
Ah,
Only
but that is against that is against the procurement rules.
Only reason is that lordship.
7-4 against it should be.
Only reason is that lordship, if tender process is completed lordship, they will, that is the reason lordship.
Okay,
Nothing is there.
Heard Mr. Ahmedaz, the learned counsel appearing on behalf of the petitioner. Issue notice, making it returnable on 5/8. 5/8, you file your affidavit
Yes.
by that. 5/8/2024. Was, as Mr. K. Gogoi appears on behalf of the respondent numbers
All the respondent lordship.
1 and 2. Was 1 and 2. And accepts notice. Pusto. Extra copies of the writ petition be served upon him during the course of the day. The petitioner herein has, the petitioner herein had challenged the notice, short retender notice dated 8/7/2024. More particularly to the clauses 3, 4, 8, 16 and 21. Huh? 9. 8, 9, 16 and 21 on the ground that they are discriminatory in nature. So it is the specific case of the petitioner that those clauses gives an upper hand to the EPSS/WCCS in the tender, and as such is in violation to the provisions of the Assam Public Procurement Act 2017, as well as also in violation to Article 14 of the Constitution. The it has been brought to the notice of this court that today is the last date for submission of the tender. The petitioner would be well advised to submit the tender. If the petitioner be at liberty to submit its tender without prejudice to its rights, without prejudice to the contentions raised in the instant petition. The respondents are directed to file their affidavit on or before 2nd of August 2024. The matter would be again taken up on 5th of August 2024. So it is made clear that the short retender notice dated 8/7/2024 or any decision taken in the said notice in pursuance to the said notice shall be subject to the outcome of the writ petition. But how do you take care, Mr. Das? How do you take care without making the GPSS or anybody as a party?
Because lordship till date, no writer has been accused in favor of anyone.
Now,
Yeah,
understood. You see, they do
is
they
what I'm
have
saying.
not an association of the GPSs?
There,
Think about that, because you see, later on it may have a problem because you are against the GPSs. If they have an association out
Yes,
there,
sir.
if that association could have been included, then wouldn't it be better? Because tomorrow, if we pass an order, I would have otherwise today, if this matter would have been there, I could have passed an order to that effect that and recording his submission that they are defaulter, GPS would not be allowed. And I would have disposed it off. But without the GPSs being there, there is a big problem, you see. Just think about it.
I'll try to find out whether it is a registered GPS.
100% there is. There is an association.
Try to
to
find
it.
out.
If you implement them, then
Record
things
it.
should be better.
Alright. Very good.
49.
Maybe
Yes.
when the mighty state is hell-bent on resorting to blatant favoritism, the Honorable Court is the last hope. But before I take your lordship to the documents, may I just briefly summarize the fact?
Yes.
Because facts are slightly long. What has happened is, this is a tender pertaining to supply of liquid medical oxygen to various hospitals in the state.
Medical oxygen.
Medical. Now, there was a tender in May 2023. There are, as in all other tenders, there were eligibility conditions, turnover clauses, experience clauses, and the requirement that the bidder should be a manufacturer, and various parameters were laid down. The respondent number 3 participated. He did not have any of the eligibility, did not fulfill any eligibility. His petition, his tender was rejected. He filed a writ petition. That writ petition is still pending. Now, next round of tender comes once that term is over. Next, NIT is floated. There are some conditions like in the earlier tender. He does not fulfill many of the conditions. He submits a representation saying that you relax this condition, relax that condition. And most interestingly, in the earlier tender as well as this particular tender, one of the emphasis, as your lordship is aware, is on Make in India initiative that has been taken. So he claims that I am not even a manufacturer. I will procure from Bhutan. So you relax all of these conditions. You, instead of manufacturer, you make it an authorized dealer, etc., etc. Multiple claims he makes, saying that you relax all of this. The authorities take note of his representation. And insofar as 2-3 of these conditions are concerned, they say that all right, we can accept it, but most of them are rejected. Now again, a corrigendum is issued, some conditions are relaxed. He still does not fulfill. He participates. We point out that even after relaxation, he is still not able to fulfill many of the eligibility conditions. What they do is, instead of rejecting his tender, they cancel the entire tender process. Now they come up with a fresh tender, virtually accepting all of the representations where they had even said we are not able to accept these contentions. They relax all of these conditions, but still some conditions remain, turnover conditions. Now, he submits his tender. We say that if you are doing it for the purpose of wider participation, all right, we will not even object to all this. Now he participates. He still does not fulfill the past experience criteria. And he has been, in spite of that, we pointed out that he has not even submitted any document to show his similar past experience. He is shown to be technically qualified. Now the problem that arises is, he is claiming that he will procure it from Bhutan. In Bhutan, the electricity charges are so less that in no circumstances I can compete with him on the price. Now, hurriedly, they have not only shown him to be technically qualified in spite of his lack of eligibility, they open the prices, and now there is a condition they are most likely to impose that on me because he does not have his own manufacturing unit. He will not be able to, his storage capacity is much less. Now there is a condition in the tender saying that the L2 will have to supply at the L1 rates, and if he is not able to supply, he will be blacklisted.
Will be?
He will be blacklisted. But we are faced with, firstly, he could not have been shown to be a qualified tenderer. Let me place those documents for your lordship. Your lordship first turn to the NIT at page 51. First, your lordship, right in the middle, your lordship will find minimum average annual turnover. Your lordship sees 2,000 lakhs, that is 20 crores. Now, years of past experience required for same similar service, 5 years. Now your lordship will kindly turn the page. The lordship will find estimated bid value is 14 crores. At next page, page 53, what I was pointing out to your lordship, that under the Make in India initiative, at the very top of page 53, your lordship will find MII compliance.
Make in India is that?
Yes. MII is Make in India compliance. Yes. Now, there are various, on that page itself, your lordship will find minimum annual, average annual financial turnover of the bidder during the last 3 years ending on so and so of the previous year should be as indicated above, which means 2000 lakhs, that is 20 crores. And at serial number 4, your lordship will find past experience of similar services. How they have split it up is like this. How they will analyze the past experience. The bidder must have successfully executed, completed similar services.
In page
over-
51, it says
I'm sorry,
years of past experience required is 5 years.
5 years.
And in clause number 4 says the bidder must have successfully executed, completed similar service over the last 3 years.
3 years. There is a contradiction to that extent. But how they will analyze is given at serial numbers 1, 2, and 3. Either he should have 3 similar completed services costing not less than the amount equal to 40% of the estimated cost, or 2 similar completed services costing not less than 50% of the estimated value, or 1 similar completed service costing not less than 80% of the estimated value. Now, if your lordship will kindly turn to page 59, these are the other eligibility conditions. Terms and conditions. Number 1, the bidder must be a primary manufacturer of LMO through air liquefaction process. Number 2, the bidder should have more than 1 liquid medical oxygen manufacturing unit in Northeast India with minimum combined installed capacity of 50 metric tons. Capacity assessment certificate from
This is the
regulatory
tender in question? This is the tender in question in which he has got it?
No. This is the one where when we complain and when they realize that he does not fulfill any eligibility, they cancel the entire tender process. Why I am showing it to your lordship is to show how systematically, step by issuing corrigendums and corrigendums and corrigendums, all of these have been relaxed. And even after that, he does not fulfill, and he has still been shown as.
Let us come to the new one.
Before that, my lord, may I just point out the representation he had made, which is at page 60. Your lordship will, that itself will show that he does not fulfill any of the criteria.
Page 60.
Page 60. On the left-hand side is the request he has made. There are 2 separate columns. Your lordship will find heading is query and reply. Your lordship will see the first query. As our plant is located in Bhutan and the storage is more than 70%, your lordship will kindly note this, mother. More than, he first says that he has more than 70 metric ton capacity at our plant site. But Bhutan government does not issue any kind of explosive or peso license. So we request you to kindly change it as the bidder must have minimum 70 metric ton LMO storage capacity with or without peso license. The license itself should be got rid of. And on the right hand side, your lordship will see the authorities are saying rejected. The standard rules and regulations laid down by the concerned regulatory authority is to be followed for all purposes as per the law of the land for related services and support system. Hence, the already mentioned criteria persists in the bid document. Now, next, my lord, kindly amend point number 1 as authorized distributor. This they accept. Similarly, my lord, manufacturing capacity should be reduced to 40 metric tons instead of 50 metric tons. This they accept. From next, having experience of supplying LMO to minimum 4 government private hospitals having capacity from 300. Earlier it was 6. They rejected this. And they go, it goes on like this, madam. And when we point out, your lordship will find at page 70, although some relaxations were given, after we pointed out, we submitted a representation at page 68. that in spite of all these relaxations, he does not fulfill A, B, C, D, E criteria. Your lordship will find that page 68 is our representation. And what they do is at page 70, they cancel the entire tender process.
No, we are not against cancellation.
We are not against cancel.
We are against the granting of the
This-
contract. Let us come to the new contracts.
New tender, your lordship will find at page 71.
71.
Page 7.
Yes.
Your lordship will straight away have a look at the minimum average turnover. Reduced directly to 800. From 2000, it comes down to 800.
Then 5 years was made 3 years.
3 years. And if your lordship turns the page, your lordship will find that Make in India is gone. There is no Make in India now because Bhutan has to be accommodated now. Now, if your lordship will kindly turn to page 73, your lordship will find, so far as the past similar experience is concerned, it is identical. That has remained. Now, if your lordship kindly turns to the terms and conditions at page 80, your lordship will find the huge difference with the earlier tender.
Yeah.
Page 80, serial number 1. The service provider bidder must be an authorized distributor. So primary manufacturer is relaxed. Next, your lordship will kindly come to serial number 2. The bidder or its manufacturer must have liquid medical oxygen manufacturing plant of minimum installed capacity of 20 metric tons. This was 50 earlier. Now next, the bidder must have experience of supplying to minimum 1 government. Earlier it was 6. And it was 500 bedded hospital. Now it is reduced to 300 bedded hospital. Then serial number 5. The bidder must have minimum 4 vehicles. Earlier it was 8 vehicles. Now, next, delivery period. During emergency and pandemic situation, the bidder must have the capacity of to refill liquid oxygen within a period of 6 hours of any medical college and hospitals under DME Assam. During routine period, the bidder must supply within 24 hours. Earlier it was 12 hours. All relaxed. Now, at serial number 10, your lordship will find this offending clause. During emergencies, such as pandemics, it is mandatory for participating bidders to promptly supply liquid medical oxygen to any of the medical colleges in Assam. This must be done at the approved L1 rates. Failure to comply with this requirement will result in the bidder being blacklisted and barred from taking part in future bids. Now, they have the liberty to notify 2 rates, L1 rates and L2 rates. Anyone becoming L2 is bound by the L1 rate and he entails blacklisting if he is not able to. Now, ultimately,
L2, L4 also has to give in L1.
everybody has to give at L1 or else he will be blacklisted.
But why this term was not challenged by anybody? Why didn't you
Because
challenge it earlier?
it was, my lord, at that time, we were totally unaware that they will be able to procure and supply at such atrocious rates. And they did not even have the turnover. So we thought that this party simply cannot be eligible. And your lordship will find that the eligibility condition, how they have, if your lordship will kindly come to the tender.
Now, what are you challenging?
We are challenging this, his technical determination of his technical qualification. If your lordship will kindly come to.
Has the tender been issued? The work order been?
They have just notified the L1 rates. If your lordship will kindly come to page 92, that is his NIT. That is his tender.
Where is the L1 notification?
It is at page 127. This is under challenge. Ready to go to sir. Ready to go. 1 minute, please.
What is the L1 rate?
These rates are at, my lord, they refer to this document 12.6, that is at page 123. These are the rates.
1526. L1 is Meghalaya Oxygen.
Meghalaya.
That is the private respondent.
Mal.
Okay, what is your rate?
My rates are at, if your lordship will kindly come to page 123, your lordship will find Meghalaya Oxygen rates
129.
124 and also 129.
So what is your rate?
Your lordship will find at page 124, 125 and 126. Because it is schedule wise, there are 3 schedules.
How are they being given?
No.
Schedule 1. L2 is 80.
So far as schedule 1 is concerned, their rate is 64 crores or ours is about 88 crores. Then schedule 2, theirs is 30 crores or ours is about 37 crores. Then in schedule 3, theirs is 19 and ours is 25. The reason is very simple, my lord. In Bhutan, the electricity charges are 8 rupees less than us. So naturally, they can supply at much lesser rates. Without even having the eligibility, he comes in. He resorts to predatory pricing only because of the advantage that he gets in Bhutan. And now he takes away. And I can show from his tender documents that he does not even fulfill the
You
technical.
didn't know that Bhutan has electricity cheaper earlier?
No, but
Ah.
we did not know that.
Other proper businessman.
We knew
Yeah.
that, but we did not expect a technically ineligible person to be qualified.
Now, where does he not qualify?
Well, I will point it out. Your lordship will come to his own tender, madam, which is at page 92. This document itself, page 92, will show that he has not submitted anything to even try to demonstrate his eligibility. Nothing about past experience. Not a single document about past experience.
What do you say about number 10?
Memorandum of agreement with so-and-so cryogenics for tankers. So far as storage and manufacturing is concerned, the requirement is similar nature. If your lordship will come back to the NIT, 40% of the estimated value, if it is 3 works, if it is 2 works, it is 50%, and if it is 1 work, it is 80%. There is not even a single document submitted to establish his similar past experience. And we have annexed his entire tender document as he has submitted.
Three similar completed surveys of not less than amount equal to 40% of the estimated cost. Estimated cost is
13.9 crores.
1391.
So we have done the
13.91.
calculation. It
So
comes
he
to
must have at least 40%.
Mal.
Three similar works costing not less than 1% of the estimated.
So,
So,
lordship may just, we have done
so
the
the
calculation.
aggregate of 3 works or aggregate of or each work?
Each work.
Okay.
If it is 3 works, it has to be 40% of the value, estimated value,
Okay.
into 3. If it is 2 works, 50% of the estimated value into 2. If it is 1 work, 80% of the estimated value. So,
So
these work out to your lordship may
to
just
boil down to the submission made, you say that he does not have the qualification in terms with this.
Yes.
That's the entire submission.
And your lordship is aware, I am not even placing that. Ronak makes it very clear that past experience is one of the relevant criteria which the authorities have to take note of when evaluating tenders. In fact, I can place-
Ronak also makes it very clear that if I grant you a stay, you have to give an indemnity.
that of course is there. In fact, paragraph 9, parameters are laid down. If I may pass on the book, please, sir.
Yeah, read it. You are referring to paragraph 9. It's not-
Paragraph 9. The award of a contract, whether it is by a private party or by a public body or the state, is essentially a commercial transaction. In arriving at a commercial decision, considerations which are of paramount importance are commercial considerations. These would be, I am relying on 3, there are several. Serial number 3 says, whether the person tendering has the ability to deliver the goods or services as per specifications. That can be determined only by past this thing. Serial number 4 says, ability of the tenderer to deliver goods or services or to do the work of the requisite standard and quality. And serial number 5, past experience of the tenderer and whether he has successfully completed similar work early. So these 3 conditions clearly are not fulfilled when the evaluation took place. And therefore, his technical, showing him to be technically qualified is expressive value.
Okay, I'll come back and hear you.
Technically, I will be that. Now, if lordship permits, my lord, tomorrow I can place the entire record of the technical bit of the response number 3. Because it relates to my lord, supply of liquid medical oxygen, my lord. That part I want.
You see, his experience documents,
Lordship.
you must be having it between.
Yes, it will be there in his technical bit document. That I will place.
So, bring it that by way of an affidavit, you're having it on Monday.
Fine.
Till then, don't issue anything.
So here, my lord, it has already been issued from 16/7. It has started, my lord. It is on my lord need basis. Whenever such oxygen is required, my lord, the medical college will give the necessary, my lord, supply orders and all, and he will have to supply. Or you will see, my lord, page 127. As per my instruction received from the Director of Medical Education, it has started 127. Lordship, you will see the second, just my lord, the line below the my lord, first para. The approval list shall be valid from 16/7/2024 till 15/7/2025. My lord, nothing will happen, my lord, till Monday. Lordship will consider it. If my lord, he doesn't have the experience, the entire work order will go. There's no point of keeping it, my lord, pending. Because we'll have to procure it from somebody. Or Friday also, my lord.
It's Wednesday, no?
Yes. On Friday, my lord, Lordship will consider a record only for the interim partner.
No interim. See, his submission is short.
Oh, yes, only one
If
point.
you had the record, I could have disposed it today. But why I need, if I have to dismiss his petition, that matter, those documents are there on record. It would have been considered. That's it. Otherwise, but another aspect has to be, have you challenged that clause? You can't challenge that clause.
So no, we have, my lord, whatever relaxations they gave, let it be. Even the unrelaxed conditions which still exist, at least adhere to them. They have reduced from 2,000 lakhs to 800 lakhs. They have reduced from 50 metric tons storage capacity to 20 metric tons. We said, all right, you want more participation, fine. But at least adhere to the declared norms, which is the law of the land.
No, that is one aspect. The second is as regards that particular clause, whereby you are to pay, the L2 has to pay in the L1 rates.
Supply.
So that is not under challenge.
So
We are challenging is we are going to the root of the matter, that you could not have determined his bid to be technically responsible.
So you file your affidavit by Monday, Friday.
Fine.
We take it up on the only bring on that because
Yes, only on that point.
I will record my submission, his submission and put it, what is required to be filed. And we have it on Monday or Tuesday, whenever it is.
Can it be on Wednesday? Monday, there's a matter in Itanagar where some act has been challenged. So
On Wednesday, we have it.
And in any case, what my learned friend is submitting is not permissible also. If your lordship will kindly see page 139 for a moment. If the tender process is through the e-market portal, government e-market portal,
they have to follow subclause 9 at page 139. All orders have to be through the GM portal. They cannot issue orders randomly.
No, that's why I'm saying, my lord, it will be on need basis. Today, there may not be the need today, my lord, but tomorrow there may be some requirement, my lord. So at least that can be procured. So on Wednesday, it can be decided, my lord. Because it's relates to oxygen, my lord, supply of oxygen. Yes, yes.
Heard Mr. I. Chaudhary, the learned appearing on behalf of the petitioner. P. Gogoi appears on behalf of the Health
1 and 2, my lord.
Health?
Yes, my lord. Health department.
Health Department and accepts the notice on behalf of the respondent number 2, Mr. S. Dotto, the learned by
There is a caveat also.
appears on behalf of the private respondent.
This one, number 3.
Instant writ petition has been filed challenging the communication dated. You are challenging this communication 11/7.
We are challenging two things, my lord. Page 91 and page 127. Page 91 is his determination of his technical responsiveness.
No, in effect is this. In effect, this is 127.
1 minute.
Challenge the communication dated 11/7/2024 in whereby the contract being GEM bid number GEM/B/504/1621 dated 12/6/2024 was approved. Thereby observing that the respondent number 3 is the L1 bidder. The petitioners herein have challenged the technical competence of the respondent number 3 on the ground that it does not fulfill the criteria so mentioned in clause 4,
1, 2, and 3.
clause 4, bracket 1, bracket 2, bracket 3 of the GM bid number GM/B/504/1621 on the ground that it does not have it does not fulfill the competence. It does not fulfill the requirement of the said clauses. The I. Chaudhary, the learned senior counsel, strenuously argued to the effect that from a perusal of the bid which have been submitted by the respondent number 3 and has been enclosed to the instant writ petition at Annexure N, it does not transpire that the petitioner, respondent number 3, complies with the said clauses. Referring to the judgment of the Supreme Court in the case of Roanoke International versus IVR Spencer, reported in 1999, 1 SCC page 492. The learned counsel has referred to paragraph 9 and submitted that if the bidder does not fulfill the requirements, it's a fit case for interference of the powers of judicial review. Per contra, Mr. B. Gogoi, appearing on behalf of the Health Department of the Government of Assam, submits that the respondent number 3 duly complies with the requirement of clauses 4, bracket 1, bracket 2, or clause 4 of the tender conditions. And as such, the question does not arise that the respondent number 3 is not technically responsive. He further submits that he would be that he would like to file a brief affidavit bringing on record the documents which would categorically show that the respondent number 3 duly complies with the mandate of clause 4 of the tender conditions. Taking into account that it is on a very limited score on which the instant petition has been filed, and the issue involved is limited to the extent as to whether the respondent number 3 duly complies with the mandate of clause 4 of the bid of the tender conditions. This court fixes the matter on 31/7/2024. Each date an attempt shall be made to dispose of the petition. The health department shall file their affidavit bringing on record those documents which should, if any, which would evidence that the respondent number 3 is duly qualifies in terms with clause 4 of the tender conditions by 26th of July 2024. And the petitioner, if so advised, would be at liberty to file their reply by 30th of July.
The lordship is fixing it up.
31st. Wednesday.
Obliged.
Right.
Obliged.
Item 50.
Yes, Mr. Vanik, what is this?
My lord, sometime.
Yes, we don't see Mr. Rahul Dor
My lord,
in bench one matters, yes.
my lord, a tender was floated by the authorities for settlement of, amongst others, markets. Panchayat markets.
Tender for what?
Markets.
Market.
29.
Then
Then, on 29th of June, a notification was issued saying that
27th,
29th, 29 at page 40,
page 40.
40. A notification was issued by the Panchayat and Rural Development Department cancelling all the tender process for the year 24-25 on the count that a new condition should be incorporated. That for the last 3 years, average 10%, if you bid more than that, then you're not in the fray. It will be cancelled. And they should be refloated on that count.
Yes.
So far, so good.
So all the tender which was issued on 27th was cancelled.
10-6. 10-6.
There is another one on 27/6.
I'll come to that, Miller. On 10-6. I'm on
What
10-6.
is this at Annexure B?
Annexure B is a decision taken by the Department of Tribal Affairs Plain Dispute, which transfers lots of carts, markets, etc. to the administrative control of the Basic Autonomous Council.
So these tender have been cancelled. Now
Cancelled.
they want to bring in a 10%.
All right. We're not challenging that. Fair enough. Although there are grounds to challenge, if you put the highest bidder limit, then everyone will bid the same. So we're not challenging that for the moment.
Anyway.
Now, if this is what the government says in the Panchayat and Rural Development Department, then certainly on 27/6/24, the decision of the authorities at Annexure B 30 to transfer, I'm on a particular market, I'm not on all, to transfer a particular market from the control of the jurisdictional Anchalik Panchayat to the Missing Autonomous Council is expressly bad in law. Now, my heart burning wouldn't have any effect unless I'm able to justify my submission in law. Now, under the Constitution of India,
there's a concept of 6 scheduled autonomous councils, and we have 3 in Assam. But there are other autonomous councils also, like the missing autonomous council, which is not a 6 scheduled autonomous council. I'll just hand over the act. On an price lordship from the legal point.
Who is you paying for missing?
Yes, come on.
My lord, the missing autonomous council was established under the Act of 1995. Now, there are 2 fundamental differences here. One is, I'm not saying the state government doesn't have the power, but the way they exercise the power is bad in law. The missing autonomous council does not have a fixed territorial boundary. Unlike Kavyang law, North Kachar, or Boro, it does not have so. If it does not have so, how do we understand which area falls under the missing autonomous council? Would my lord be pleased to have?
How are you aggrieved?
I am aggrieved because we would participate in tenders floated by the Anchalik Panchayat. You cannot in law keep the area of the Anchalik Panchayat intact and take away the market and put it under the administrative control of the missing autonomous council. This is expressly bad in law.
Now, who are you?
I am a tender.
So,
We will participate. No, we cannot
participate with the missing.
Well, that would be one way of saying that, open for all. But the other view is that, is it permissible in law the way they have done it? I would address my submission to your lordship, my lord.
There's a
Whatever
division bench out there to question all these things.
the law, I'm challenging the decision to transfer is bad in law. I'm not on that. Only to the decision. My lordships. For a
Whether it has happened rightly or wrongly, whether it has the power or not, yes, it may have, the state has the power or not. That is another aspect of the matter. Are you challenging the power?
we are challenging in the writ petition.
You are challenging the power of the state? What
We
are you
saying
challenging?
That notification 27/6/24, by which it was transferred, we're challenging that, and we say, go ahead with the tender. Go ahead with the tender, refloat the tender with whatever conditions you want to put. If bad in law, we may come, but that's a different issue. We held out a promise that we'll cancel it now, we'll refloat it again, and it is transferred to a missing autonomous council. We say it's bad in law. We do not say bad on facts. We say it's bad in law. Because under the missing autonomous council, they have executive powers. Over
They have?
They have executive powers. Over the council area, whichever it is, it's not a boundary. It's wherever there are satellite areas or core areas in the entire Assam, it's there in the act, that would form a part of their area. It's not a fixed boundary, ABC. Now, if the missing autonomous council would like to have its powers enlarged, if I may put that word, then it has the power to frame bylaws. Those bylaws need to be approved by the government and they need to be published in the official gazette. That's the act. That's from the missing autonomous council. If the state government wants to do something to amend or to bring in some new powers, new rules, then there's a procedure under 79. May your lordship have it for 79 for a moment. 79, 1 and 2. There's a last page of that. May I do? The government may make rules providing for any matter which with any provision of this act is required to be prescribed or to be provided for by the rules. Every rule made under this section shall be laid as soon as may be after it is made before the state legislature while it is in session for a total period of 14 days, which may be comprised in one session or in 2 successive sessions, and if before the expiry of sessions immediately following the session or the successive sessions aforesaid, the state legislature agrees in making any modification in the rule, or the state legislature agrees that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect as the case may be. Provided, however, that such modification or announcement shall be without prejudice to the validity of anything previously done under the rule. The more important is, my lord, 81. This is from the state government head. The other one was from the missing autonomous council, and that's rule 23. Well, section 23. 81 is more important. Your lordship takes for a moment. May I read? Nothing in this act shall affect the application of any law, whether made before or after this act, to the council area, unless such law specifically provides for exclusion of the council area of such application. My lordship, for settlement of this act or matters whatsoever, the Panchayat Act is holding the field. It's under the state. Schedule 7, the state has framed it. Now, this Panchayat Act is of 1994 and the Message Act of 1995. In view of this section 82, 81, it says any act formed prior or later than the Act of 1995 shall govern the field in the missing autonomous council area, the council area, unless specifically excluded. So the hearts and markets which are there under the Panchayat Act, in a jurisdictional Panchayat, if I may say, I'm only on one, not on the rest of the entire list. For the government to say that the Missing Autonomous Council Act would apply would be bad in law, because there is no exclusion in the Assam Panchayat Act that this would, even by way of amendment, if I may say, that this would not apply in the council area. But if the government would like to do that, then they have to do by way of 79. There is no way there can be en bloc transfer, but I cannot challenge the entire list. Therefore, I've challenged that market which affects my right. Once the
Mr.
jurisdiction,
Bonik, I am not satisfied as to how are you agreed.
my lordships, under the Assam Panchayat Act, a jurisdiction is vested by the act.
You are a tenderer.
I'm attended.
What has happened by 27-6? 27-6, what they have done, in view of the no objection given by the Panchayat and Rural Development Department, they say that these particular markets, these particular ferry huts, which now fall within the missing autonomous council area, and these ferry huts, and remember, these ferry huts or these markets are bounded. About the missing autonomous council not being bounded is immaterial. These particular ferry huts, which have been specified out there in the notification of 27-6-2024, categorically mentions that these ferry huts or these markets now will become under the control of the missing autonomous council. Now, this missing autonomous council, by virtue of section 20 of the Missing Autonomous Council Act, has the power to levy taxes and fees. How are you agreed?
But the power to settle is not akin to the power to levy taxes. Power to levy taxes is on a field on which they can exercise. But the power to
So by virtue of 81, that if they want to settle, they can very well take the into application of the PNRD Act.
we have not yet reached that stage, Miller. The government of Assam is singing in two tunes. The Panchayat and Rural Development has brought out a notification pursuant to a cabinet decision that will refloat the tender. And here, the Tribal Affairs Department, if I say correctly, has transferred the very thing to the Missing Autonomous Council, whereas Missing Autonomous Council does not have the power under the Act to settle. To levy tax is one thing, but to have the power to settle is quite another. The power to settle comes under the Panchayat Act. And the Panchayat Act, by virtue of section 81, does not exclude Missing Autonomous Council. It operates in the Missing Autonomous Council area. Two departments having two different stands in the same state of Assam. And even if they want to borrow some parts, theoretically, then 23 comes in. The missing element of counsel, if it's an endeavor move from the missing autonomous counsel, 23 would come in.
Now they don't have the rules or bylaws?
No. If they have, they need approval for that. 23 for a moment, internal page 7 of the act, chapter 23, rule 23, section 23. If I may read, the General Council may, subject to the provisions of this act and the rules made under the subject to the approval of the government, then subject to the approval of the government, make bylaws to be applicable within the council area with respect to all or any of the matters enumerated sections 18, 19, 43, 44 for the regulation, control, and administration thereof. All bylaws made under subsection 1 shall have effect upon their publication in official gazette. Now, so far as this case is
So your submission is to the effect that although they have transferred it, the ferry huts or the markets and all, the missing autonomous council cannot settle because they don't have the power to settle. But what do you mean by settling?
settling is the power to call for tender, carry on the tender process.
Power to call for tender is you don't require an act for that
By lordship.
or the bylaws.
That can be one view of the matter. If it is followed from your lordship, that will be the law. But so far as in
No, that is
94
not for what I say. It is well settled that whenever you are going to settle any public lodger, you are required to do so by following a transparent mode. That is the law.
correct, that
It is
power
the law under
my
141.
lord, so far as correct. To settle it for public lodges, it has to be by way of tender. I am not on two
But
ways
what
with-
do you do by settling?
I am on one page with your lordship.
No,
What I
no,
want is
Mr.
that
Bonig, what do you do by settling? By settling, what do you do? Why do you settle?
for the management and revenue, both.
No, you don't settle for the management. You settle it for purpose of earning revenue.
Absolutely. Management and revenue, both.
So at the end of the day, if you have the power to collect the tax or levy or license, or give a license for the purpose of use of a market, or for the purpose of running a market, that power is given under 20.
My lordship. So far as now the overlapping part, if I may say. Section 81 says, unless the exclusion clause is there in any act or any law, if I may put it, enacted or brought in force prior or after the Act of 1995, it would apply to council area. We cannot have two acts overlapping each other. So the Panchayat Act holds field over the missing of.
How does the Panchayat Act hold the field?
The Panchayat Act is an act which has a three-tier mechanism: the Gaon Sabha, the Antarik Panchayat, and the Jila Parishad. So far as the Gaon Sabha is concerned, it is comprised of a body, which has the territorial, which I'm putting it, 6,000 to 10,000 persons must be there in the area. Accordingly, the Anchalik and the power to settle under section 105, 106 of the Panchayat Act. If I may just point it out. Settlements of huts by Anchalik Panchayat, section 105.
So this has to be given because it has a three-tier mechanism.
Three-tier mechanism is for administration, but the power to settle.
No, therefore, the power has to be given
Absolutely.
specifically.
Correct. So power to settle the huts by.
But when the missing autonomous council has an executive body, which is in terms of the act, they can very well do it.
They can do it. We do not say they do not have it. But those markets which are under the Panchayat Act, by version of section 81 of the Act, the exclusion clause being not there, the Panchayat Act overrides the Missing Autonomous Council Act to that extent. And therefore, the transfer.
When will the Panchayat Act apply?
Panchayat Act will apply in the jurisdictional area wherever the markets, huts whatsoever are there. A particular Panchayat cannot take beyond its jurisdiction. If a particular market X is within the jurisdiction of the Panchayat Y, then why 105 comes into play?
That act doesn't apply to anywhere.
Section 1. It shall extend to the whole of Assam in the rural areas except autonomous district under the 6th schedule of the Council. And
So therefore,
the exclusion is not there.
there is an exclusion.
No, 6th schedule of the autonomous council, Milo.
Yes.
6th schedule is not missing autonomous council, is not a 6th schedule autonomous council. That's my entire case.
Shall extend to the whole in rural areas except the autonomous districts under the 6th schedule of the which have been or hereinafter being in the municipality or
The missing autonomous council being not a 6th schedule autonomous council. Under section 81 of the Missing Autonomous Council Act, the Panchayat Act overrides.
now whether within the missing autonomous council there is a Anchalik Panchayat?
No,
Then if there is no formation of the
it's not-
Anchalik
therefore-
Panchayat, then where is the
Therefore,
question of
therefore, my
settling?
initial submission was the Anchalik Panchayat would have a territorial area, whatever is the area. Within that, there will be huts, ghats, parghats, markets, whatsoever. They'll be settled. Now, what is the area of the missing autonomous council that bears some relevance? Because the lordship takes the act for a moment. Takes the act for a moment. Section 2, subsection. Section 2, subsection Q, OPQ. Satellite areas means the area or areas consisting of non-contiguous cluster of villages predominantly inhabited by scheduled tribes population having 50% and above as a whole in the cluster and not necessarily in the individual villages. And 2U, core areas, means the compact and contiguous areas predominantly inhabited by the scheduled tribes population having 50% and above as a whole in the area and not necessarily in the individual villages. Therefore, if persons from particular community would satisfy these terms of 2P and 2Q, then the satellite area and village town, this core area would spring up. And the preamble, if I may read, that would have a bearing also. In fact, in the next case, the Panchayat department has written to the Missing Autonomous Council, kindly honor the government decision. Well, I'll place it when the next case comes. In this case, not there.
Yes, Mr. Wattakul, what do you say?
Lordship, so far as his first contention is concerned, your lordship, that the area, your lordship, of the missing, it is notified area, your lordship. There is a gazette notification, there is a core area and satellite areas. Those are bound, their specific boundaries are there. Since it is not pleaded in his petition, your lordship, I did not bring those gazette notification right now, but it was a notified area, gazette notification is there, specific boundary is there. And within that boundary, your lordship, missing autonomous council functions, number one, your lordship. So far as second point is concerned, your lordship, first of all, he will have to satisfy this honorable court regarding this locus, your lordship. Ultimately, your lordship, whether it is settled by missing autonomous council or by the Panchayat, your lordship, if his transfer would have come in the way of his submitting tender, your lordship, then I can understand that he has some case, your lordship. But that is not the case, your lordship. As of now, we have not gone for your lordship, tender notice has not been issued, your lordship. Therefore, your lordship, my humble submission at this stage, your lordship, that he has no locus to challenge this notification. If at all someone has locus, that is the Panchayat concern, your lordship, but the Panchayat concern is not agreed by the act of the government, your lordship. They have accepted it, your lordship. Second, and thirdly, your lordship will kindly see, your lordship, that this section 18 and 20.
Basic question is
Lordship.
that how are you going to settle? Otherwise, we are not concerned.
Lord.
About how are you going to settle?
Lordship will kindly see the power of settlement so far as the missing autonomous council is concerned, your lordship. This honorable court has interpreted section 18 and 20 in one judgment, your lordship. That is, your lordship, 2015, 2 ZLT, your lordship. Page 352, your lordship.
Yes, what does it say?
It says, your lordship, para 45, your lordship. Now the question that falls for consideration, whether the MSC Act authorizes settlement of ferry by the MSC. It was related to a ferry, your lordship. 46, but before that, it will be appropriate to deal with a contention advanced by Mr. So-and-so regarding implied repeal of section 106 of 1994 Act to extend this sum. The same comes in the conflict with section 18 and 20 of the MSC Act. I am leaving it for a moment, Your Lordship. Then para 49, though section 18 of the MSC Act start with a non-obstante clause, so far as the present case is concerned, namely settlement of a ferry on the strength of section 20 of the MSC Act, it will be noticed that the provision makes it abundantly clear that the powers of the General Council in connection thereto is subject to the provisions of any other law for the time being in force, and therefore this is not an appropriate case to decide the plea of repugnancy. Then 50, as held by the court in Vidhan Mudoi, unless a ferry has been declared or created as a public ferry within the meaning of section 4, there is no legal impediment under the Ferries Act or any person and authorities establishing, maintaining, running a private ferry. This I am leaving Your Lordship. Para 53, viewed thus. Para 52, in RBI, it is held by the apex court that the interpretation must depend on the text and the context. No part of a statute and word of a statute can be construed in isolation. Then, viewed thus, it will be doing violence to section 20 of the MSC Act if the section is interpreted to mean that MSC is only authorized to impose levy and collect taxes. The expression ferry constructed or established and managed as appearing in section 22A of the MSC Act has to be interpreted to mean MSC is vested with the power to construct, establish, and manage a ferry. Management of a ferry will necessarily include management by lessee through a process of settlement by following transparent procedure like notice inviting tender. That power has already been upheld by the Honorable Dishonorable Court, Your Lordship.
No, therefore I said to him,
Lordship.
by having a ferry service or a market,
Lordship.
what do you do? Do the government or the missing autonomous council only collects taxes or levies fees
Lordship.
or tolls?
Lordship.
That's it.
That's
Nothing more than that.
Lordship.
If that power is given, then how to do it has to be conducive with Article 14.
Lordship.
That's all.
That
Nothing
is-
more than that.
Lordship.
And if it is done in terms with Article 14, the power, you only require the power.
Lordship.
The power is there. But when you do it, the requirement as per the Panchayat Act is on the ground that there is a three-tier system.
Lordship.
So you have to say that this particular area will fall under the Anshalik Panchayat. This particular area will fall under the Jila Parishad. This will fall under the other Parishad. Now, in the instant case, if you see MAC, you see the village councils.
Lordship.
The village councils have been also endowed with the power
Lordship.
for collection of tolls, taxes
Lord.
and all.
Lordship.
And overall, the MAC is also, the
Lord.
executive committee also has the power to do
Lord.
so. So this is how it is being done.
Lordship.
So under such circumstances, the question does not, it is a case of how you regulate.
Lordship.
If there is nothing mentioned in the regulation, there is no bylaws or anything framed, it has to be in a manner which is conducive with Article 14.
Lordship. That is your Lordship.
That has to be the understanding of
Lordship.
20, because what you require is the power,
Lordship.
and the power is there.
Lordship.
So far as I get your lordship on that. Now, there will be two pertinent things we could call for lordship's consideration, as I see it now. Number one, would there be a restriction in participation so far as the rest of Assam is concerned and being not person from a particular community or scheduled tribe? That would affect rights of all.
What do you want?
If
A notice or a dismissal?
either ways, maybe.
Either.
Either ways, I leave it to your lordship, but that contention advanced, that section 81 holding the field, the power to transfer would be bad in law. That is the only argument for it.
How to transfer? How can it be bad in law? You have not challenged that power.
We have said the notification by which they transfer is bad in law.
Why?
They challenge that. Because they,
Who are you?
I would be a participation.
So
a
that is
person
why I said
participating in the
initially,
tender.
the division bench is there for that, for having a PIL. Not for the
Well, lordship, let's have the
226.
next matter for a moment. I'll just show a document. The next matter for a moment. There's a document.
Yes, to yes. Yes.
Page 44.
Page
44. That is issued by the Chief Executive Officer, Tinsukia Zilla Parishad, to the Principal Secretary, Ms. Nyari. So with reference to the above, I would like to draw your attention that as per Cabinet decision and subsequent government notification number 29/6/24, all ongoing tender process for settlement of hard ghat for the year 24-25 has been cancelled, and the existing lessees have been allowed to continue till further government instruction. Accordingly, we have cancelled our tender process and allowed all existing bidders to continue till further instruction. This includes Shri Bhuvan Pegu, the legitimate lessee of Amarpur Dibang Ghat, who is allowed to operate the ghat till further instruction. It is further to be noted that Amarpur Dibang Ghat is being settled by Tinsukia Zilla Parishad for around 20 years. However, sir, the direct settlement of Amarpur Dibang Ghat from your end to one Shri Naveen Pegu for 2 years for settlement amount of 2 lakhs, while so-and-so dated 12/6/24 has not yet been revoked despite government notification referred above. In view of the above, you are requested to honor the Assam government cabinet decision in the regard and revoke the settlement order made firm against Amarpur Dibang Ghat immediately to maintain law and order in the Amarpur Dibang Ghat area. In the second case, it was in a particular ghat. It was also transferred like that, but prior to transfer, they had settled it. And direct settlement. They say, please don't do it. Kindly honor the government decision.
One thing, PNRD, how are you exercising power once it now belongs to the missing autonomous council?
Notification.
They may give it on daily basis. They may do whatever may be. Who are you? How are you issuing that communication?
This is on 36/2024.
So this is after 27/6. So how could you issue this communication? Because you have no power now.
That is, my lord, a communication between Chief Executive Officer and the Principal Secretary, my lord. Just information.
Whatever may be. How can you cannot say anything about those persons. You have no business. So once it is being transferred, so now it belongs to the missing author. How they do, what they do it illegally, then we are there. If they do rightfully, Mr. Bonik is there to challenge.
Maybe just for information, man.
This is not for information. You categorically say at page 44 that kindly honor what is there we have extended. With reference, I'd like to draw your kind attention to so and so, all going and have been cancelled, and the existing lessee have been allowed to continue till further government instructions. Accordingly, we have cancelled our tender and allowed all existing bidders to continue till further. This includes even the legitimate lessee of even who is allowed to operate till further instructions. Now, does this Amarpur Dibang Ghat falls within missing autonomous council?
Cannot, man.
Does it fall within missing autonomous council?
They transferred. There is nothing for the missing autonomous council below. Satellite areas, core areas, it may tomorrow sprung up in any area. What we are saying is that.
No, that is not the case.
No.
It is a
That is not the
notified area,
case.
it will have to be gathered.
Here is the case whether I'm saying about 27/6, whether this Amarpur falls within
It would be
missing
bordered in both
autonomous
sides.
council. Huh?
Both the autonomous council area and the government area, if I may put it
We
this
are concerned with Amarpur. What is this? Amarpur
physical
Dibang
layout, the
Ghat.
government will clarify me. The physical layout. It was under the Panchayat area.
Amarpur Dibang.
For the Anchalik Panchayat. The tender notice is like it's under the aegis of the for the Anchalik Panchayat. And the tender notice under the Assam Panchayat Act 24/25. That's how it reads.
Here, 99, page 39. Serial number 99. So how are you exercising this power?
Cannot, madam. I fairly submitting.
The 99 is under the Khodia Anchalik Panchayat. That's how it says. My lord,
Whatever may be, you see, lease D. He leaves D are that under the transport department and
Leaves D.
115 Parghats lease D under the transport, under the administration of the year.
Page
So,
36.
so under such, no, page 39
First
of the
36.
second one.
First
We are
56.
concerned. We have asked you a particular question, you have not been able to understand, answer that. Therefore, I had the pain to point it out. Page 39 of the second writ petition,
Yes.
serial number 99, Amarpur Dibanghat. Amarpur Dibanghat now it belongs to the Missing Autonomous Council. Who are you to say anything? Isn't it, Mr. Bottakul? There are nobody to say that you extend them or what not. You grant an extension.
So,
It's
my
for them to do it rightly or wrongly, whatever they do.
basically, two departments are saying in two different tunes, on the same issue.
Not department, Your Honor, one officer.
This is
No, no,
some
I'm not on
officer
that,
of the Chief
The
Executive Officer.
Panchayat and Rural Development Department at page 41,
Are
whatever,
you asking for stay of this
only these
communication?
two. Only these two. Rest they will go ahead.
No, are you asking for stay of this communication of 36? No.
No, 36 two. We are playing only this with respect
Anyways.
to adjudicated, under adjudication, there was some interim protection until a very short
What
date.
protection?
Otherwise, they go ahead and say,
Thank goodness. You don't have a case.
but so far as the exercise of power.
Be happy enough that I'm issuing notice. Both the cases, same person. Oh, you got another person now.
There's a caveat to second.
Huh? Who are you? Why you have been brought in?
Even prior to transfer, he was settled with you. '27 it was transferred,
No,
26 he was settled.
Ah, this one. Wait, we'll take care of that at next one. Here we issue notice, making it returnable on. How much time you will require to file your affidavit and bring on a court?
Also 4 weeks.
Oh, wait, issue notice making it. Huh?
They may not go ahead with the settlement process in respect because otherwise the matter becomes improper.
How are you concerned? If they go ahead with the
Then one
settlement process,
observation may be
you
that,
participate.
that observation may the partition may not be restricted only to the particular community or.
No, there is
Right,
no
that-
question of your.
That may be recorded,
confining it to a
if the
particular
participation is
community.
not confined, then we may not have the case also. That may be,
Hello.
that may be there.
Issue notice making it returnable on 9th of September 2024. So appears on behalf of Mr. S. Kotak. One? No. Kotak appears for respond number 5, 6. Mr. Ardhor appears on behalf of the respondent number 1. Mr. S. Doctor appears on behalf of the respondent number 2, 4. And your government? No, 51 we have not come. Who is government? Wednesday appears on behalf of the respondent number 7. As all the respondents are duly extra copies of the petition served upon them during the course of the day. The instant petition has been filed challenging the communication dated 27/6/2024 issued by the Department of Tribal Commissioner and Secretary to the Government of Assam. Commissioner and Secretary issued by the Secretary to the Government of Assam, Department of Tribal Affairs, Plains Dispute, whereby 7 markets operated by the Panchayat and Rural Development Department, 153 numbers of Bajaj falling within the missing autonomous council area, and 2 numbers of fishery service and 115 numbers of parghats under the transport department was transferred to the administrative control of the missing autonomous council with immediate effect. It is a challenge, it is the case of the petitioner that the transfer which has been made, the manner in which the transfer has been made by the government of Assam is not in consonance with the provisions of the Missing Autonomous Council Act 1995. Mr. Esbonik, the learned counsel appearing on behalf of the petitioner submits that though power has been given under the Act of 1995 to levy tax, toll, as well as collect license fees, but there is no power so granted to the missing autonomous council in terms with the Act of 1995 to settle the markets, bazaars, ferries, as well as the parkers. Referring to Section 81 of the Act of 1995, Mr. Bonik, the learned counsel appearing on behalf of the petitioner submits that in the the Panchayat and Rural Assam Panchayat Act 1994 would come into play, and in view of the overlapping of the Assam Panchayat Act of 1994, the missing autonomous council could have no power to settle the markets, ferry huts, as well as the park huts in Cochin. On the par contra, Mr. Esbotaku, the learned counsel appearing on behalf of the petitioner, respondent the missing autonomous council submitted that the petitioner has no locus standi to challenge the notification dated 27/6/2024, in as much as the petitioner cannot be a person aggrieved. Further, referring to the learned counsel further submitted that it is no longer res intriga that the missing autonomous council has the power to settle markets, ferry huts, park huts, etc. In view of the judgment of it's a coordinate bench.
Which one, Your Lordship?
You refer to a judgment, na?
Lordship, that is 2015 2 ZLT, Your Lordship.
Name.
Anjan Taye versus State of Assam.
Coordinate bench.
Coordinate bench.
Judgment of a coordinate bench of this court in the case of so-and-so versus so-and-so reported in
2015 2 ZLT 352.
so-and-so. Also.
If Lordship permits.
The learned counsel further submitted that there are notifications to the effect as to marking out the boundaries of the missing autonomous council as well as the satellite areas, and submitted that he would bring on record those by filing an affidavit. Rejoining to the submissions made by Mr. Esbotaku, the learned counsel appearing on behalf of the petitioner, Mr. Esbonik, submits that the petitioner is apprehensive of the fact that if the missing autonomous council in the meantime tries to settle the bazaars, ghats, etc., the petitioner may be debarred from participation. Mr. Esbotaku submits that the question of debarring the petitioner, if otherwise qualified, does not arise. Taking into account the above, this court fixes this matter. Taking into account the above, the respondents are directed to file their affidavits by, when did they fix the matter? September. Are directed to file their affidavits by 31st of August, by 30th of August 2024. And the petitioner, if so advised, would be at liberty to file the reply.
Well, if I just place it,
What?
in respect of fisheries, there was an interim protection.
What?
In respect of fishery, there was an interim protection by a
Lordship, so far as fisheries are concerned, Your Lordship, I have considered that, Your Lordship, there is no, Your Lordship, notification transferring those fisheries to this. Therefore, Your Lordship, I have considered that that's why
And the other matter, same issue.
But 12/6 it was settled below, and 27/6 it was transferred.
Huh?
From the communication at 36/2024, I could come to learn that prior to transfer, 27/6 they were transferred, rightly or wrong. But 12/6, the Missing Autonomous Council unilaterally made a direct settlement for 2 years with the private respondents who's under KPA. Even prior to transfer.
So you are challenging,
I'm challenging both the transfer as well as the settlement.
why?
The transfer, I have argued in the earlier case, the same legal
The private respondent has been settled directly
directly
without any notice.
without tender.
My knowledge, it was
How is it
direct for 2 years at the rate of
How?
2 lakh. Lordship, that I will not take.
Which stated, then if we stay, then who runs it?
Logically, after
It's a
36
ferry.
It's a petition.
Then who runs it? You can run it,
Lords.
but you cannot settle it like this. Can issue notice, making it returnable on 9th of September 2024. The
My lord, I
so
mean,
and so
point out one
appears on
thing, my lord.
behalf of Ekita AKSA.
Number 3.
Mr. S. Bhattakur appears on behalf of the respondent number 6 and 7. The Adhar appears on behalf of the respondent number 1. Mr. S. Dutta appears on behalf of the respondent 2, 4, 5. Mr. P. Bora appears on behalf of the respondent number 3. Mr. So appears for the respondent number. So who is on caveat. He has a weaker. Who is on caveat appears on behalf of the respondent 9.
The only, my lord, I noted.
Wait.
Page 31, my
We
lord.
have notice
Sorry,
making it returnable on 9th of September 2024. Pusto. The instant matter was taking into account that all the respondents are duly represented, extra copies of the writ petition are directed to be served upon them during the course of the day. Pusto. Taking into account that the issue involved in the instant writ petition is also the main issue involved, taking into account that the main issue involved in the instant writ petition is also involved in the analogous writ petition being WPC number, and so the instant matter be tagged along with the other writ petition. In addition to that, it is also seen that pursuant to that even prior to the transfer being made on 27/6/2024, the Omorpur Dibangar, which now falls with the Missing Autonomous Council pursuant to the notification dated 27/6/2024 and was with the Inland Water Transport Department then, was settled by the Missing Autonomous Council directly with the respondent number 9 by an order dated 12/6/2024.
I want to point out, my lord, page 31, my lord.
Page
Although
31.
the formal decision was taken on 27 June, my lord, the NOC was taken in the month of 5/1/2024.
But without their transfer, how could it have?
My lord,
Couldn't have.
that is reflected, my lord.
This court have taken note of two aspects of the matter. The first being that the notice that the settlement was made by the Missing Autonomous Council upon the respondent number 9 directly without following any transparent procedure, which prima facie violates the mandate of Article 14 of the Constitution. Secondly, the said settlement was made even prior to the transfer being formally made on 27/6/2024 notification. under such circumstances, in the next day, the communication dated which one?
In page 44, that's there, you know,
No, his settlement.
second last paragraph.
Huh?
I've made a statement. I don't have a copy of that. I could get it. Second last paragraph.
The settlement made in favor of the respondent number 9 by the order number MAC/RR/DS/308/2022-224/123-125 dated 12/6/2024 in respect to Omorpur Divanghat shall remain state. The missing autonomous council, however, would be at liberty to run the ferry service by following the due process. At last you got something there.
The 2 lakhs amount, my lord,
Huh?
they have taken prior to settle from me, 2 lakhs, it was settled at 2 lakh. They have taken
You
already.
see, on 9th you get it with interest.
My lordship also gave a lot more in the first one, that all would be allowed to participate. That was the only bone of contention.
Huh?
They conceded all would be allowed to participate.
I said that.
Yes, that's,
The
I got
lordship
everything.
has already
Got something.
No, I therefore
Yes,
said that.
absolutely, correct.
That he said that
Yeah, he said,
everybody-
yes, that's,
subject to following being
Absolutely.
revealed. AP Pathak to come. There's a wrong date given by. Should have been 19th, they should file the affidavit and matter would have been taken up on 24th. I've wrongly fixed it on 26th and 31st. Hmm. 31st will be, you know. It will go develop. Yes, what is this?
Yes, my lord, may it be the lordship. My lord, in brief, my lord, the current petitioners are, my lord, this self-help group upon whom, my lord, the fishery was settled by the government of Assam way back in the year 2019 for a period of 7 years by following the due process of law, my lord. Now, my lord, the petitioners were continuing to operate these fisheries, and suddenly, my lord, on 25th of June 2024, recently, my lord, the missing autonomous council authority, they again settled the same fishery, which was settled with me, to a different incumbent, that is a private respondent herein, my lord, and have settled it for a period of 2 years, my lord. So the basic contention herein, my lord, is that the council did not have any authority and jurisdiction to settle, my lord, 60% registered government fisheries, because, my lord, the power has been bestowed totally upon the state government and the deputy commissioner, my lord. Now, my lord, quickly, I'll take my lords to annexure 2 of the petition, which is my settlement order. My lord, may kindly come to page 47, my lord. This is the settlement order on 6th of September 2019. Order was issued by the Fishery Department. Proposal for settlement of Orika Part 3 fishery submitted by DC, Sibsagar by letter dated. Order of the Honorable High Court, your lordship can skip this. This is regarding settlement of Dorika Part 3 fishery in Sibsagar district. It appears that the Deputy Commissioner invited tender for settlement of fishery in the light of the order of the Honorable High Court dated 11/2/2019 in WPC, my lord, so and so, as earlier lease expired on 25th 12/2018, my lord. Now, my lord, these are the 7 numbers of bidders. I will quickly take your lordship to the relevant part, which shows that I have been given.
You have been handed over a possession.
Yes, my lord. I'll come to
Then?
that. Yes, my lord. My lord, at page 48, the subsequent page, the petitioner's name has been given as 4th highest bidder, and the relevant part, your lordship will find the paragraph just below it. From the scrutiny of the tender documents, have your lordship found? From the scrutiny of the tender document as well as other record, it is seen that the bid offered by the Notun Gotonga Rajiv Self-Help Group of rupees 1,60,000 is the highest.
I've read it. Now,
Now, my lord, may kindly come to the next annexure at page 50, my lord. Annexure 3, which is the certificate of handling over of possession to the current petitioners, my lord.
10th of September.
Yes, my lord.
Then,
my lord, after taking possession of this fishery, my lord, recently, my lord, prior to the filing of this petition, the same authorities in the missing autonomous council, they issued an NIT, and in that NIT also, the current fishery in question was enlisted to be, my lord, tendered by the missing autonomous council. So we immediately assailed that particular NIT, if your lordship will kindly come to the writ petition which we have filed at page 53 by the same writ petitioners challenging the NIT. And the order is, my lord, 19/7/2022 at page 54, my lord, wherein an observation has been made, my lord, in relation to the conduct of the missing autonomous council. It says, my lord, in the interim until further order, the respondent missing autonomous council neither shall settle nor shall hand over the possession of any water body of 60 to 40% category fishery of the state as well as of the Fishery Development Corporation that falls within the territorial jurisdiction of the missing autonomous council, including the part of so-and-so fishery, my lord, and further shall not disturb the fishing activities of the lessee with whom such water body is settled by the concerned authority, even though the entire area or part of the water body falls under the territorial jurisdiction of the said council. The relevant part which protected us, my lord, is paragraph number 8, my lord. 3 is also relevant, my lord. The learned senior counsel for the petitioner has also drawn attention to this court to a communication dated such and such, whereby Fishery Department has made it clear that fishery in question, though may pass through the missing autonomous council, council does not have any jurisdiction as no power have been vested, transferred to the council for such settlement. The petitioner society registered, sorry, my lord, is aggrieved by notice dated such and such issued by the council, by which the Dorica Part 3, that is the current fishery in question, is one of the adjacent fishery for which tenders have been invited. Now, paragraph 8 says, in view of the above, it is directed that till returnable date.
And then thereafter,
My lord, the current interim order has been passed.
Which
Your
one?
lordship will find it at page 42, my lord.
42,
My lord. This has been passed recently, settlement order of Min Mahal. In pursuance of the approval of the missing autonomous council, following Min Mahals are settled for 2024-26 with effect from 1st July to 30th of June 2026 in favor of the lessee. Now, my lord, this particular fishery is at the, my lord, the third column, that is Dorica Min Mahal Part 3, and it has been settled with one incumbent called Viren Singh Mili at the value of 50,000 for the period 2024-26, my lord. And as per the terms of this particular impugned communication, they
where
have,
is this fishery?
yes, my lord,
Where is this fishery?
this fishery is the concerned fishery that I am sitting lessee at page 42, the third fishery, my lord. The first column, the third row, Dorica Min Mahal Part 3. On the left-hand side, name of the Min Mahal at serial number 2, my lord.
Yes, yes, what do you say? Where's the missing?
Missing, lord.
You are there? You appear for missing?
I'm not for missing.
Oh, no.
Yes, yes, I have
Where's Mr. Esbot Thakur? He's the missing. Have you served the copy?
involved Mr. Pothakur matter in the morning itself that the matter has been posted before a lawsuit. He was supposed to come.
Autonomous council is no, as per our contention, government contention is that there is no government approval, cabinet approval also, and they have no right because they are not under 6th schedule lordship. And
Huh?
they are not under 6th schedule.
Then
Also lordship missing autonomous council, clause 81 specifically states that if something has to be empowered, then the fishery rules has to be amended. There is nothing like that. Again, 23(1) of the missing autonomous council also does not empower them, though 18 empowers them, lordship. Section 18 empowers them, missing autonomous council, for executive power of our fishery, but 23(1) says that they have to take prior approval from the government.
for what?
For anything, for any.
No. You see, recently on 27/6/2024, there has been a lot of fisheries being transferred into the jurisdiction of fisheries and fisheries are not transferred. So there is already a stay operating in some other.
Three cases.
Recently, there is a stay being granted. The fishery has not been transferred. That is what I have been told by Mr. Bhattakur also in the earlier matter.
But difficulty is, my lord, the Assam Land Revenue Regulation is the source and the genesis of the power that has been vested upon the state government. My Regulation 16, my lord.
Now, there is a concession being given out here
My lord.
on the earlier occasion by Mr. Bhattakur. Today is 19/7. Today is 17. These matters are all coming up on 19/7. Similar matters.
On 15 meters. After that, this petitions were filed, Lordship, around 10 left.
Just wait for 5 minutes, let Mr. Bhattakur come.
Actually, mostly one executive meeting is going on. Our meeting is going on, so he's in the.
You take it up at 3. Up at 3. Let him be present. You have served the copy upon him. No?
In fact, I've informed those people. I'm obliged. Sir. Huh?
It's the same.
1, 2, 3, 4, all are same manner. Cause is same manner, issue is same.
কোন ভয় রাখো? Yes.
Lordship, this interlocutory application is related to WPC 4185/2023. And Lordship, may kindly peruse.
You are the petitioner.
Yes.
You want to implead whom?
Simply this Mr. Viras Sekia Dan additional linear implemented. Why it is necessary, therefore I beg Lordship, kindly peruse 14, page 14 of writ petition 4185.
Writ petition.
4185. Then it can be 4185. Page number 14.
Yes.
Page number 14, serial number 4. It was stated that technical bid opening date 14/07/2023. This is the office at Durhat, an additional disciplinary implementation office in Guwahati. And formal order was issued next day immediately on 15/7, next immediately. And this IA application, page 26 may calculate, then it will be moved.
2073.
207. IA application, page 26. Is good.
Yes. Then
Then on 14th, technical bid was opened at Durhat. After that, necessary formalities to be taken, like technical bid evaluation, formation of tender committee, financial bid evaluation, without doing anything. And subsequently, after doing everything, that file to be sent back as per this page 26 to Guwahati office. Then Guwahati office will get it. He is in Guwahati. It is in that. Nothing was done, and immediately on single tender, next day. That means that immediately next day on 15th of July 2023, work order issued. The type responsible side. That is. So implement necessary because earlier these 2 orders by this honorable court implemented already respective superintendent engineer page 11, page 12, 15. Page 12 and 15.
no, understood. But Mr. Applicant in person saying you want to implead the office or the person.
In person.
Why?
Because that person is not here now. He has gone to other on deputation. And secondly, impeachment is necessary. Otherwise, case will be because any post may be occupied by any person in subsequent point of time. Post
So
can-
how are you concerned? We are concerned with the illegalities in settling. Have you made allegations in your petition alleging malafide against that particular person?
particular person, yes.
Have you made
Yes,
against Mr. Dheeraj Soikia?
yes.
Where in your petition?
Not it. I answer. That time he was not made the party.
Understood. So you can't make somebody a person unless you make amendments out here in your petition.
No, that unless the honorable court pass an order for amendment, then it will be done.
So you have to seek for an amendment. See, Mr. Applicant in person, you are a lawyer.
No.
To make a person by name a party, an official, when it is necessary to show that this person had acted with malice in fact, not malice in law, malice in fact. He had acted malafidely. He had a personal vendetta or personal intention to do so. If otherwise, you normally implead the office because he is the person who has the office. You are concerned that this particular tender could not have been issued by anybody in such a quick span of time. And if it has been done, it should have been done in a particular manner.
I got your point, Lordship. One shall impede him in the repetition.
Yes. So unless you have specific
I
allegation,
got your point.
you cannot make him by name.
Yes, Lordship, yes, I do agree. So, Lordship, if I please to pass an order, accordingly, I will take this.
He wants to implead that person by name.
Lordship.
So by name, if he has to be
Integrity
brought
is
in, then
not-
there has to be specific allegation against
Yes.
him in the writ petition.
Yes.
Unless you don't have it, you cannot.
But, Lordship, may I?
You have to file an application to that effect that you want to seek insertion of certain paragraphs and also for impleadment. So once you do it, I keep this matter pending, this application pending. You file an application for amendment of the writ petition. Okay?
Lordship.
The applicant in person submits that he requires 2 weeks' time for filing an application seeking appropriate amendment to the writ petition, taking into account that taking into account that there are certain allegations of malafide against the person whom he wants to array, against the official whom he wants to array in person. Taking into account the above, list the matter again on 12th of August 2024. In the meantime, the petitioner is given the liberty to file appropriate application.
Obliged.
7 for admission.
Being is pending regarding some work done during the concert
do you-
election, my lord, the temporary work. Annexure A, B, and C, my lord. After completion of the work.
Which department?
Concert and rural development, it's done under the executive DRDA.
What is your stand, the government stand?
Concert. 7. Admission is
What is your stand?
Can they give a direction to the
No,
contractor?
no. These type of matters, small matters. You need to finish it.
Lordship, in this,
Type of matters, no time. Subject to payment of interest by you. You
And
say
the
interest,
Lordship, this one is non-payment of bill. Non-payment
so
of
you
bill.
verify and pay.
Lordship.
I hope. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss
And Bora,
Bora appearing on behalf of
respondent number 1 and 5.
1 and 5. And who is appearing for election department? The R2P appears for respondent number 2. 2 and 2. And Mr. D. Gogoi appears for respondent number 3 and 6. And Mr. MCT appears for the respondent number 4. The instant with petition has been filed by the petitioner, being agreed by the respondent authorities not releasing his dues to which he claims to be entitled to. It is a specific case of the petitioner that the petitioner is a registered contractor of the Public Health Engineering Department. And during the Panchayat election 2013, he was ordered by the Executive Engineer PHE Mongoldoy Division to complete the works relating to tap, pumps and hand washing system, 12 numbers of hand pumps and 25 numbers of low-cost sanitary latrines at the Mangaldoi College for Panchayat elections. It is also, it is the further case of the petitioner that the three work orders were issued in that regard, which are detailed here in under paragraph 3 of the writ petitioner, A1 to is detailed here in under 1 to. It is the case of the petitioner that the petitioner is entitled to an amount of rupees 2,26,482.81 against the aforementioned works which have been completed by the petitioner. However, the respondent authorities, in spite of being requested time and again and represented time and again, have failed to repay the same. And it is under such circumstances the instant writ petition has been filed. This court duly takes note of that pursuant to the filing of the instant writ petition, notice was issued by this court. However, till date, no reply has been filed by either of the respondents. Taking into account the above, this court is of the opinion that it would be in the interest of justice to pass an appropriate direction upon the respondent number. PHE, Panchayat, who gave the order?
Yes, madam.
PHE.
Project Director, DRDA.
No, PhD no. DRDA.
Project Director, DRDA. My lord, annexer app.
Appropriate direction upon the respondent number 2, 2, 3, 1, 2, and 3.
Yes, my lord.
1, 2, and 3, the appropriate direction upon the Commissioner and Secretary to the Government of Assam, Panchayat and Rural Development Department with Dispur, Guwahati, as well as the respondent number 2 and 3 to make appropriate verification as regards the petitioner's entitlement. And thereupon, if it is found that the petitioner is entitled to the said amount be released after due verification. Full stop. The verification be completed within a period of 2 months from the date a certified copy of the order is served upon the Commissioner and Secretary to the Government of Assam Panchayat and Rural Development Department, as well as to the respondent number 2 and 3. Full stop. Pursuant to the verification being carried out within 4 months thereafter, the payment, if the carried out, and if it is found that the petitioner is entitled to the amount, the payment being made within a period of 4 months thereafter. Petition stands.
PHE has forwarded, it is verified and.
Whatever may be,
demand
you
has been to-
do your
But
verification and
respondent 5 also has to be directed then, because the demand, the annexures, my lord, page 15. the
Which
individual
5?
Rights to
Which
DRD.
5?
Hello?
Which 5?
PNRD, my lord, DRDA.
PNRD, we have given the directing to the commissioner.
Fine.
Commissioner is enough.
Yes.
Tomorrow you may say, ask the peon also. He may carry the file, issue a read for that. Yes, who appears for Bokazan? You.
I'm appealing for the respondents, but Mr. LP
What
Sharma
is this
madam
matter
was-
about? Bokazan Cement Corporation Limited Employees Association. What is this matter?
This is, my lord, with respect to, my lord, the promotion and other things, they have come against the ex parte order, my lord,
Ex parte order for what?
of the labor court, my lord.
The court records have come.
And I've been informed, my lord, now this union also not active, my lord.
No,
Now there are
no.
two unions which is active. This present union is not in act.
This union is no longer there.
No, it is there, but it's not active, my lord, because the person who was controlling the union, Mr. Pratap Bora, he is no longer, I think so, there, my lord.
Hello. None appears on behalf of the petitioner on call. Full stop. It is also seen that on the earlier occasion also, none has appeared on behalf of the petitioner on call. Full stop. Taking into account the above, this is the matter again on 7th of August 2024. it is observed that in the circumstance that the petitioner is not represented, it shall be deemed that the petitioner is no longer interested in the matter, and accordingly, appropriate orders shall be passed. The J-Roy appears on behalf of the Bokazan
Bogazan, Cement Corporation,
Cement Corporation.
3, 4, 5, and 6.
Yes. What is this? You want money?
It's not really one of Contractor institution. And they have completed the work as per the government scheme. But what happened in 2017 to 2017? Government introduced some schemes, 141 schemes for the protection of the erosion of the Brahmaputra.
What?
Erosion of the Brahmaputra, protection of the erosion of the Brahmaputra.
Hmm.
And for that, tender was called for. And this petitioners association, throughout the Assam, they have submitted their tender. Accordingly, they have got the work order, and as per the work order and specification, they have completed the work. So for the payment is concerned, my lord, there are the central government schemes and the central government guidelines is there. My lord, the payment of central government was 90% and the state government was 10%. And our priority in this petition is, my lord, the guidelines which were issued by the central government, that should be implemented and our fund to be released. It's a very simple one. In that case, my lord, central government, on behalf of the central government, respondent number 1, 7, and 8 filed their affidavit in opposition. The state government has not filed any valid affidavit in opposition.
No. Why it has been filed by a union? Why it has been filed by an association?
It was the allocation of the work was toward the Assam, and they have a registered association, registered under the Water Resource Department of the Government of Assam. And
how is it that each person is going to, each person has an individual claim?
yes, they are
You will only show that he is at best the association may come up and say as to whether withholding the amount is legal or illegal. You may say that. But can you ask for a direction, that the direction for payment?
we pay for, we come to this court for release of the payment for the contractors.
How?
Otherwise, we
How will this court adjudicate as to which contractor is entitled to how much amount?
that will be decided by the respondent number 9, the executive engineer.
How can an executive engineer decide?
My submission is to this fund as per the scheme that has been released. That has to be released. Non-release of the fund, they did not get the money till that after completion of the work. That is why we came before your lordship to issue a direction for implementation of the government.
Who are you paying for the central government? Has the central government filed the affidavit?
Yes.
What does it say?
It simply says they release their fund.
They released their 90%. Where is that?
Sudden changes.
Please see. Mukul Kumar Chandra Lokar, Executive Engineer, Brahmaputra Board, to swear the affidavit. Yes.
Page 4 of the affidavit lordship and third paragraph, it is written, it is to be met. Change to eligibility. From the in the change in the policy from the pool of eligibility, it will revolve 42%. Earlier was 32%. Distribution is centrally 10%. Between 4 or 5.
So it will be like the state will release its shares, then the center would release its share.
As per the second.
Your kindly see your paragraph at paragraph 8 of your affidavit.
It did that lordship earlier 90%, 10% central share. Later on,
Read the entire thing.
That which as regard to the statement made in paragraph 8 to the repetition, your deponent begs to state that cannot matters of record. It may be pertinent to mention here that there are altogether 44 FMP schemes in the 11 5-year plan, which are physically completed but have got financial liabilities. The completion report for all these schemes and the utilization certificates for the amount of fund released so far have already been submitted to the government. The reason for non-release of central share is not for want of above two reports. It may be specifically stated here that initially the funding pattern of this scheme for central share 90%, state share 10%. Accordingly, the state has released its entire 10 state share, but later on, since 28/10/2015, the funding pattern has been changed to central share 80% and the state share 20%. Thus, the state of Assam has to release the additional 10% state share. This portion of state share is yet to be released by the government of Assam, for which the central share is not yet released by the Ministry of Water Resources, Government of India.
So means that you are to release your 10%, then the government will release. Now, in the meantime, the proposals have all expired, which will be seen from the next subparagraph. So under such circumstances, what is the course? This affidavit was filed when?
2018 years.
So what is the present status?
I have to take some.
And take note of the affidavit which have been filed by the respondent union. You file an affidavit. I'm giving you time to fix it. This is the whole matter. We fix it on 13th or 12th of August. File your affidavit up to date. What is the present status? It is seen that an affidavit in reply has been filed by the affidavit in opposition has been filed by the respondent number 9 on 2018, wherein certain details have been given to the effect that certain release of funds have been made. It has also been mentioned that since 2015, there has been a change in the sharing pattern between the central and the state government, whereby the share of the state has become 20 as against 80% by the central. It is also seen that it is also mentioned in the said affidavit that with only upon the release of 10% by the state of Assam, the central government will release their portion. Further to that, it is also noticed that the amount that the proposals have also been proposals have all requires revalidation. This court also takes note of the contents of the affidavit, wherein it has also been mentioned that out of the 41 schemes, only 7 schemes have been completed. Taking into account that the affidavit was filed in the year 2018, this court directs the Water Resource Department to file an affidavit by 9th of August 2024, giving an update as regards the status of payment so released, and as to whether the revalidation has been sought for, and also as to whether and also as to how many schemes have already been completed. The list of matter again on 12th of August 2020. Yes, what is this?
Yes, my lord, in this case, my lord, the petitioner, my lord, it is a case my lord, relating to my lord selection of a LPG dealership, my lord.
Huh?
LPG dealership of the respondent corporation, my lord. What has happened in this case, my lord? Lordship may kindly come to page 26, my lord. Pursuant to, my lord, the advertisement for selection of the LPG dealership, my lord, by the respondent. I have applied, my lord, and I was declared as successful, my lord. Lordship may kindly come to page 26, my lord.
Yes.
Is it addressed to me, my lord, Simarani Mollik, my lord, and down below, my lord.
Please to inform that you have been declared a successful candidate in the draw of lots conducted on Iman and Iman LPG at subject to you. You are hereby requested. Then,
Yeah, then, my lord, at page, my lord, page.
you came under lot 1.
My lord?
You came under lot 1.
Yes.
Okay. Then,
So, my lord,
100% the
page 29,
case
my lord.
must be that you did not submit your document.
My lord, what has happened, my lord, since the land doesn't fall in the advertised location, so alternative land was asked to submit.
How can you give it?
Yes,
Alternative land.
under the provision, it is there, my lord. Lordship may kindly come to page 29, my lord.
Documents pertaining to land go down in the name of the applicant or member of Iman, so and so.
Page 29, my lord.
Yes, page?
Page 29.
Yes.
So, my lord, in the
The
first paragraph.
application you have mentioned that the details offered for the godown is so and so. And during the field revision, the land was shown to the Iman, but it is found that the land subject does not fall in the advertised location, that is the result of which the land would not be considered for construction of the LPG godown as per the eligibility for the as per the guidelines of the land directives, or in case if the offered land for the year that is selected, which is shown in the application, is found not eligibility criteria. And so then the selected candidate can offer an alternative land which is owned by the applicant, member of the family, grandparents, so and so, so and so. The last date for submission of the application as specified either in the advertisement or the corrigendum, if any. Therefore, you are requested to provide details of suitable alternative land fulfilling all the eligibility criteria as per the procedure. The unified area. Since no fresh registration is required for any alternative, then the information sought above can be furnished within 7 days.
So accordingly, my lord, at page 31, we have submitted documents, my lord. Page
Okay.
31, my lord.
All matters
So
situated all yeah. Then
then, my lord, I have annexed one document, my lord, which shows, my lord, the land. of
there is the
one
impugn
katta.
order.
Yes, imping water, lordship, I will take to lordship page 34, my lord.
Huh?
Excerpt 7, my lord.
Page
Page 34, my lord. Excerpt 7, my lord.
application. Please refer to your application upon receipt of the amendments. Then
Then, my lord, they have what they have at page 35, my lord. They have selected respondent number 5, my lord. So I can drawing a
Where?
lot, my lord. Page, next page 35, my lord.
there was a fresh draw of lots.
This job lot by which, my lord, this Saurabh Kumar Bora, my lord, who is an assistant teacher of a school, my lord, he was selected, my lord. So we have challenged both this letter as well as his selection, my lord. Now, my lord, the respondent, my lord, they have filed their reply, my lord. They are saying, my lord, lordship may kindly come to their reply at para 7.
As you satisfy your case, let us not go to the respondent.
Now they are saying that, my lord,
Now, not they saying, you satisfy
yes, my lord.
yourself. First,
now-
how do you come into?
yes, my
You
lord. Now,
admittedly did
the
not
reason-
submit any
the
document.
reasons for rejections, my lord. The reason for rejections, my lord, I agreed, my lord. The petitioner write letter dated 10/11/2018 and answer 5 to the petition submitted the photocopy of the sale deed of 24/3/2010 of her husband along with the no objection certificate in the form of affidavit dated 5/11/2018 of her husband as required under clause 1W of the voucher. Sale deed 24/3/2010 speaks that the petitioner, her husband purchased a plot of land measuring 1 kata covered by tag number 163, patta number 42 of village Salmara under Hojai Revenue Circle. Besides, NOC dated so and so 5/11/2018 mentioned about a land measuring 9,000 square meter in as much as the date of registration of the sale deed registered.
Where are you reading from?
Yes, my lord. The affidavit, my lord,
Of 1 to
of the respondent, my lord.
Where paragraph?
Para 7, my lord. Internal page 3, my lord.
Then the pursuant to the letter dated 3/10/2018, the petitioner by letter dated demand submitted a photostat copy of the sale deed of her husband along with a no objection certificate in the form of an affidavit dated yes. Then
Now, my lord, the only defect what they have found, my lord, in an affidavit that has been submitted, my lord, as a land of my, if I go an affidavit, my lord, by the husband, my lord, in his affidavit, my lord, at page 13, which begins in this paper,
Page?
page 13, my lord, of this opposition, my lord.
then
Page 13, internal page 13, my lord. Here, my lord, at page 14, column, my lord, instead of writing the date of the sale deed, my lord, 2010, my lord, it was mentioned 20 July 2018, my lord. And that was the only defect they have found, my lord, because it doesn't match with the land records what I have submitted. That means the sale deed which I have submitted, my lord. That is what they wanted to say, my lord, here. So she will see, my lord, at page 14, internal 14, my lord. Date of registration is 20 July 2018. My lord, tag number, pattern number, everything matches, my lord. Only, my lord, date of registration was mentioned 20 July, my lord.
where is the sale deed?
Yes, sale deed, my lord. I have craved, my lord. I have the sale deed with me, my lord. I'm just saying your lordship.
You have not enclosed the sale deed.
I have craved, my lord, in my
We dismiss the petition on that ground. Goodness. Your entire case hinges on the sale deed. Why didn't you enclose it?
craved, my lord.
Oh,
I will bring this on record, my lord.
the sale deed you submitted.
Yes, it is there.
Why did you crave?
My lord. I crave, my lord, because
Matter has been
it-
pending from 2019. Does it take 5 years for you to bring on record that sale deed?
but what they wanted to say is that, my lord,
There's nothing to say.
that the sale deed and the NOC date,
Not inclusion of the sale deed is suppression of material facts. We dismiss it on that ground.
I have stated everything, my lord, on record, my lord. It is there on record, my lord.
What is there on record?
Yes, my lord. I
The
will just,
sale deed is the most important thing. Whether you submitted that sale deed or not.
yes, my lord.
Yes.
Yes. Lordship, may kindly page 7,
What is the name of the person?
Ranjay Malik, my lord, is a husband, my lord, and the land belongs to him, my lord. I have stated in para 7, my lord. In my review.
You stating it out there in paragraph 7 doesn't make any sense. You file an affidavit in reply also, then also you did not bring on record the sale deed. Why?
They have only mentioned, my lord, that the date.
Is that the original sale deed?
I don't have the photocopy.
If you don't have the original, then this must be manipulated.
They have also submitted by photostat copy of the sale deed, madam.
Ah, it's manipulated.
The circle
That
officer
is why you
asked
did
them,
not
this-
enclose.
This sale deed is not
It's
available. in the record.
manipulated. Hello, go to the division bench on that ground. Dismiss on that ground.
But, my lord, what they have stated, my lord, in the report, my lord,
What?
the report, what they have stated, my lord, in the
We
NOC. my
vacate
lord,
the
the
interim
affidavit.
order. Who is appearing for the respondent, private respondent?
I am.
You are for the private
No,
respondent? No.
I was not appearing, my lord. So he is an assistant teacher. I have annexed the copy of the order, my lord, by which, my lord, may kindly see, my lord, page 80, my lord. He is an assistant teacher of a school, my lord, and he has been.
What?
Respondent number 5, my lord, who was allotted with this selection, who was selected for the LPG distributorship, my lord. He is an assistant teacher, my lord, and the writ petition has been filed by him before this honorable court, my lord. I have annexed a copy of that order, my lord. Lordship may kindly see it.
So an assistant teacher is not, cannot. So
That he can, my lord.
why? Is there a bar? Is there a bar to give it to an assistant teacher?
The government employee, my lord.
So government employee, he may leave up his job. He may find the LPG distributorship more profitable.
It's the court, my lord.
The counsel appearing on behalf of the petitioner submits that he would like to bring on record the affidavit by way of an affidavit, the sale deed in question, on the basis of which he had submitted the alternative land. Leaves the matter after 3 weeks. This court, however, is not inclined to extend the interim order. Headline he was last line. But this is not expected from counsels like you. So there is some good reason why you have not brought on record that sale deed. Why? Why you did not bring on record the sale deed when that is the main document on which your entire case hinges upon?
That is what at that time was not even available. Doesn't say it so, my lord.
What? Your entire case is based on that. You thereafter, okay, I understood. Thereafter, your entire case, now you want to say that the sale deed is of the date is wrong. The date they have mentioned it wrongly. It should not have been 27 2000 year.
Husband was writing the date, my lord, in the affidavit, my lord. Instead of 2010 date, my lord, they have mentioned.
That is what, na?
Yes,
The sale deed you have mentioned as 27 2018 in the affidavit. Use and there was a variance between the affidavit as well as the actual deed of sale, which was of 27 2010. Don't you think that that is the main document on the basis of which your entire cases hinge? And not bringing on record that document itself is a case for which your case should be, you should be non-suited. This court is, however, not inclined to extend the interim order, taking into account that in spite of pointing it out, that in spite of the fact due opportunity was available to the petitioner to bring on record the sale deed in question, the petitioner have failed to bring on record the sale deed.
reply.
Sorry, let's tender. Just settlement hall am I no? At the respondent number 4. This using this as stamp for 10 hall minor. Out of 1700 cubic meters and more, open 700.
Madam, does anything remain in the instant repetition?
Infractions, my lords, period is over.
Huh?
Period is also over, my lords.
Yeah.
From 16 to 23, it's self from my lord, synopsis itself, and it's clear. 16 to 23, period of 7 years.
Finally, 1 week time will be granted to file our rejoinder affidavit, my lord.
Setting aside the notice dated 7/6/2018, 27/6/2011, and during directing the author to reconvene a new royalty, giving due consideration to 752 cum of sand upon which the petitioner has obtained the transit pass, directing the petition respondents to issue transit permit in favor of the petitioner against the payment of the 11th year. So the remaining that portion, I think something remains.
Something in what that cannot be granted because he has stocked the material. As in violation of the rules, my lords, a Mohalda cannot stock the materials. He was caught stocking the materials. My lord. He was fined there on, my lords.
You have filed your affidavit.
Yeah, our affidavit is on record.
1 week time will be granted.
For what? The 2019 matter. There's a stay. There's a stay. Annexure 2 letter is hereby state subject to payment of rupees 4,500 out of the outstanding compounded dues of rupees a within 10 months. There's some stay. There. You seem to be not interested. At the request of the learned counsel for the petition, a matter stands adjourned to be listed after the October vacations.
All right.
October, right? After Puja vacations.
Contractual bill value, Puja, my lord, in cause list, my lord, name of the respondent not shown, my lord.
Hmm?
Name of the respondent not shown in the cause list, my lord.
How much? 70,000. Which department? PWD. But Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the PWD department on call when the matter has been called. The case of the petition, huh? None has appeared on behalf of the petitioner, PWD department. The case of the petitioner is that the petitioner was issued on disposal Tamser disposal. In terms of Tamser Ali.
14.
So we put Mr. B. Gogoi is there, na? Gogoi is for PWD. B. Gogoi appears for the PWD. Dispose of Poribo. Tamser Ali.
This petitioner, my lord, there was in my lord advertisement for allotment of retail outlet petrol.
Huh?
There was an advertisement for allotment of my lord petrol from my lord retail outlet, my lord. From my lord Nilbagan to Murajar, my lord. So, my lord, from Nilbagan to Murajar, my lord.
Okay, then
my lord, this this applicant got qualified, my lord, for the draw. Thereafter, my lord, he was called to attend the draw of lots. He was successful, my lord. Thereafter, my lord, would kindly see page 50, my lord. Annexure 4, my lord.
Yes.
Then, my lord, page annexure 5, my lord. Thereafter, my lord, the respondent number, my lord, 3, my lord, informed that the
Wait, Mr. Tiwari. You come to Annexure 4, you mean to say that I should immediately jump to Annexure 5?
carried, my lord. We are pleased to inform you that based on draw of lots of
For selection of
retail
retail
outlet dealership,
outlets, so and so you are hereby declared as selected. There is a preliminary intimation towards you whether what. Then what happened?
then, my lord, by annexure 5, my lord, we were allocated, my lord, and the land evaluation committee said that they will visit the land on 13th of September, my lord. However, my lord, annexure 6, my lord, the
Then
my lord, the land evaluation committee, my lord, after 2 months communicated that my land, wherein I've given the documents for setting up the petrol pump, my lord, does not confirm, my lord, with the measurement. However, my lord, that was given 2 months after. But my specific things in the application is that the person came but did not measure the land, my lord. The land evaluation committee person who came on my land, my lord, did not measure. He only came and stood and saw the land and thereafter he left. Thereafter, my lord, immediately after receiving annexure 6, my lord, he immediately made a applicable survey of the land. So a registered surveyor, my lord, annexure 7, my lord, and my lord, it exceeds what they had required for, my lord. There is 35-meter frontage into 35-meter depth, my lord. My one is 37.500 into 40-meter depth, my lord.
yes, Mr. Bhattakur.
The talks were going on between the client, petitioners and the.
What talks? There cannot be talks out here.
Public.
This is a public
Yes, ma'am.
largest being submitted.
Yes.
Where is the talks between once you have passed an order?
At the time
When the
of
matter is
on the
pending
day of
before
land
the-
evaluation, my lord,
we dispose it of,
Yes,
go
sir.
and measure in presence of them.
Yes.
And after measurement, if you find that it
Yes, sir.
meets as per this,
Yes.
go and settle it with him. Matter over.
Yes,
What else is required with this
Give your
type of matter? The instant with petition heard Mr. A. Tiwari, the learned counsel appearing on behalf of the petitioner, and Mr. S. Bhattakur, the learned counsel appearing on behalf of the respondent number 2, 3, and 4. Mr. S. S. Roy appears on behalf of the respondent number 1. The petitioner herein is aggrieved by the action on the part of the respondent authorities in rejecting the 8's application for award of the retail outlet dealership from Nilbagan to Murajhar Post Office on SH 19 Howrah Road in the district of Hosai under the open category advertised, which was advertised on 25/11/2018. It is seen from the materials on record that the petitioner, pursuant to the advertisement which was issued on 25/11/2018, participated and submitted his application, her application, and also offered its land, offered her land, her own land,
No, please hold that.
huh?
Please hold that.
Offered her leasehold land. Full stop. The respondent authorities have conducted a draw of lots and selected the petitioner. Selected the petitioner preliminarily, subject to satisfaction of the verification of documents in the land by the communication dated 14/2/2019. Subsequent thereto, the petitioner was duly informed that the Land Evaluation Committee would visit the location of the land in question. Full stop. It has been specifically averred in the writ petition that the Land Advisory Committee, Land Evaluation Committee, member of the Evaluation Committee duly came to the land but did not make any measurement. And full stop. Be that as it may, on the ground that the land did not meet the dimension of 35 meters in frontage width, 35 meters in depth, the candidature of the petitioner was rejected by the impugned communication dated 20/11/2019. And it is under such circumstances that the petitioner, being aggrieved, has approached this court. It is relevant to mention that the petitioner, pursuant to coming to learn about the impugned communication dated 20/11/2019, have carried out measurement through what is that? Registered surveyor, and wherein he had certified that the land in question was 37.5 meters in frontage and 40 meters in depth. Full stop. Mr. A. Tiwari, the learned counsel, appearing on behalf of the petitioner, submits that the respondent authorities, in spite of the issuance of notice, have not filed any affidavit or have denied to the contention so made in the writ petition. Full stop. This court have also heard Mr. S. Bottago, the learned counsel, appearing on behalf of the respondent number 2, 3, and 4. Full stop. The issue which is involved in the instant writ petition is as to whether the land in which was offered meets the requirement as per the advertisement, which is 35 meters in having frontage and 35 meters in depth. Full stop. The said issue can very well be settled by a re-verification made by the Land Evaluation Committee, full stop, in presence of the petitioner. Accordingly, this court disposes of the instant writ petition by interfering with the communication dated 20/11/2019 and thereby directing the Land Evaluation Committee of the respondent number 2 to carry out the evaluation, verification of the land measurement details, and thereupon take a decision as to whether the land in question so offered by the petitioner meets in terms with the requirement of the advertisement. Full stop. In the circumstance, the said the verification so conducted shows that the land does not meet the required verification, required measurement, does not meet the required measurement area as stipulated in the advertisement. The respondent authorities should be at liberty to pass appropriate orders. It is, however, observed that in the circumstance such orders are passed which are prejudicial to the interest of the petitioner would be at liberty to approach this court. With the above, the instant petition stands disposed, interim order stands vacated. What? They want to open a shop. Interim order, I am vacating it, that is why. Now they want to do it, they don't do it, don't do it. What to do? Why do you need a time frame? You were already happy for the last 5 years, keeping the matter pending.
Came up, my lord, twice, they took time for filing the affidavit, my lord. My lord, a time frame maybe, my lord, 1 month, my lord.
That is their lookout.
I am the successful prisoner. I'll get the work, my lord, the moment if it is there, my lord. I'll have a work, my lord. I'll have my livelihood.
Before parting with the record, this court duly takes note of the submission made by Mr. A. Tiwari, the learned counsel, to the effect that a time frame may be granted to be given to the respondents to carry out the necessary verification so that the process can be culminated at the earliest. This court is of the opinion that it is absolutely within the wisdom of the respondent authority to do so. Under such circumstances, this court would not like to pass or comment anything on that. However, it leaves it to the wisdom of the respondent authorities to do so. Not necessary? Making it returnable on the next date, 19/7? Because your submission will be the same. Either एक ही होगा.
My lord, may I just make a small submission, my lord? In item number 2, my lord, in item number 2, my lord, the issue is, my lord, verbatim, but this settlement has not been given to anyone, which is open to settlement, and in pursuant to an order of this honorable court, a direction was given to the state respondents to call for fresh NIT. Now, instead of calling for fresh NIT, the Autonomous Council have given the settlement to the private respondent. Otherwise, for the rest of the cases, we are all these sitting SEs of our respective fields, my lord. So in item number 2,
There is no sitting.
there is no sitting SE in item number 2, my lord. That is the only difference between these, my lord, the item.
So item number 2 is not a person who is a sitting lessee.
No, my lord. He is just a prospective bidder who is awaiting to participate in the tender process in pursuant to an order of this honorable court where he was a writ petitioner. We have challenged a temporary and an ad hoc basis adopted by the government in giving this fishery on daily basis. So that was cancelled. That was cancelled, madam. That was cancelled.
Lord.
Cancel.
And
Cancel, Lord. That, yes,
Then what right do you have?
I'm a prospective bidder awaiting for participating in this bidding process.
Then they will issue notice.
Tender process, they are ought to, my lord, take out. However, due to the impugned actions of this respondent MAC, there is no prospect of now issuing any NIT because the MAC has already taken over possession of that bill. The bill which was supposed to be settled by the state government now has been settled by the missing or.
We'll look into that. Let us first concentrate on 1, 2, and 3.
1, 4.
1, 3, and 4. 1, 3, and 4. Notice making it returnable by 19/7/2024. Stop. Mr. S. Bottakur appears on behalf of
6 and 7.
6 to 8 minutes.
Now we can't have such a short notice. We do one thing. It has already been settled. With
This
number
case
9.
has been settled but not taken possession. The private respondent has not been given possession, but the order of settlement has been done.
Then we fix another date. Notice making it returnable on 19th of August 2024. The petition who appears on behalf of respondent number 1, 2, and 3, 4. Mr. S. Bottakur appears on behalf of 6, 7, 8. Mr. M. Shetty appears on behalf of respondent number 5. As the respondent numbers 1 to 8 are duly represented, extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 9, steps be taken by way of registered as well as usual. In addition to that, the petitioner is also directed to effect justice service upon the respondent number 9 by put it to the registry of this court and file an affidavit of service on it. The case of the petitioner herein is that the petitioner is a settlement holder of Darika Min Mohol, Part 3. Which was settled with the petitioner by an order dated 6/9/2019. And the petitioner was handed over possession on 10/9/2019. The said settlement was for a period of 7 years from the date of handing over of possession. The respondent Missing Autonomous Council had, prior to the impugned order, had earlier also issued a similar order,
Notice NIT matter.
issued a similar NIT
Dated
for
7/7.
settlement of the said Mohol, which was stayed by this court by an order dated
19/7/2022.
19/7/2022 in WPC number 4662/2022. During the pendency of the said proceeding, the respondent Missing Autonomous Council, through its principal secretary, had also issued settlement of the Darika Min Mohol Part 3 for a period of 2 years, that is from 2024 to 2026, in favor of the private respondent. It is against that the petitioner has approached this court. This court have also heard Mr. S. Bottako, the learned counsel, appearing on behalf of the Missing Autonomous Council. And nothing could be shown to the effect that the Missing Autonomous Council has authority and jurisdiction to settle the Darika Min Mohol Part 3. Under such circumstances, this court stays the settlement order dated 25/6/2024 insofar as the Darika Min Mohol Part 3 is concerned till the next stage.
I'm highly obliged.
What about the others?
May I kindly take up
Number
item
3 and 4?
3, my lord. First. 3, my lord, 3560 Dilip Hazarika.
What is that Mohol?
This is a Mohol under AFTC now, my lord, Assam Fishery Development Corporation of 40% fishery, which was settled with me in person to order of this honorable court. Quickly, I'll take my lords through that order at page 43.
You are appearing for both, no?
Randalls? Yes, I'm got them from both.
For 1 to 5. That's all. The petitioner was. Where is your settlement order?
Yes, my lord, settlement order is at page 68.
68.
68. And there was another order, my lord, making some amendment at page 70.
Settlement order agote legis. So this is which Mohol?
This is called, my lord, Eliadunga Krishna Sigakur Min Mohol.
Eliadunga Krishnakur Bill. With effect from order dated 27/7/2021. Yeah.
And another order at page 70, my lord.
The state order subsequent thereto. This is what?
This is regarding, my lord, waiving of my bank guarantee.
Not necessarily.
And my
And
taking
the
over
possession was handed over on
my lord, page 71, my lord, from
dated
8/12/2021.
12/2021.
And thereafter, my lord, the impugned order was.
Here there is no writ petition.
My lord, here, there is no pending writ petition. It was in the earlier stage, my lord, in person to which it was settled with me.
তাৰপিছত সেই আগৰখনত যে writ petition ৰ কথা লিখিছো সেইখিনি গুচাই দি খালি এইটো কৰিব at the same order, it was same order.
Okay, same order.
25/6/2024 settled there with Yadunga. Favor of whom?
One, namely Mr. Noren Mili, private respondent.
Respond number 9. Stage till the next stage. And here,
Yes, ma'am. Similarly, in the next petition, that is 3561, my lord. The settlement order, my lord, would find it at,
it is 14th of March.
yes, my lord, 14th of
14th of March
2018.
2018. Possession handed over
Yes, my lord.
on
Yes, my lord. My lord, page, annexure 2, page 43, from 16 March 2018.
in March 2018. Possession handed over.
And
And
thereafter,
econ
my lord,
all, yeah,
this impugned order has been issued.
same impugned order, 25/6. Econ item number 2. Yes, now 2 come to the.
Yes, my lord. In to my lord, the brief background is that, my lord, the current writ petitioner was actually having some issues earlier pertaining to this fishery, and he approached this honorable court challenging, my lord, the settlement given to the private respondent therein, my lord, because on daily basis it was settled. This court clearly indicated that there will be no daily business of settlement, my lord, and allowed the writ petition and directed the respondent to settle the fishery by inviting fresh tender. I will quickly take to the just operative part of that order, my lord, at page 80, my lord. 73 is the order which was passed in my favor. Page 80 is the main operative part, my lord. Paragraph number 16. Paragraph number 16. The state respondents are directed to take steps for issuance of fresh NIT to settle the fishery. It is the connected concerned fishery. It is also made clear that state respondents shall not settle the fishery on daily basis with respondent number 8 till final settlement is made by the state respondents, my lord.
And
thereafter, my lord, again, what they did, they again, my lord, on the basis of the order, my lord, they basically disregarded and made a daily basis settlement of the same fishery. Then again, I approached this court.
They made a daily basis.
They again made a daily basis settlement in spite of this order. I again challenged that order. And in this manner, in the second writ petition, the court strictly observed that there will be no daily basis. And they have basically cancelled that daily basis immediately. And the writ petition was allowed. At page 83, your lordship will see.
I've seen it. And
Then, my lord, the earlier order was, my lord, was to be given effect to. And we were awaiting that the new settlement will, my lord, come, my lord, new NIT will be published. But with the passing of this impugned order, my lord, this bill has been now settled by the MSC, Missing Autonomous Council Authority, and has been given to the private respondent, my lord. And we are the prospective bidders. We were awaiting in person to this court's order that this bill will be settled by following the due process of law.
Sir, Bhattakar, how is Missing Autonomous Council doing all these things? Means, are you inviting tenders? Nothing.
Lordship, so far as the fisheries are concerned, your lordship, they have invited 10. There,
Tenders were invited in this case.
no, so far as these 4, your lordship, probably no tender. I have not found them in this list. Your lordship.
No, these you cannot challenge otherwise.
Because I am one of the
You
interested.
can only challenge on the ground that no tender has been issued.
Tender, yes, my lord. No tender has been issued because I do not know whether my learned fellow will be in a better position to tell whether they have initiated the process for tender or not, my lord. But now the problem is, my lord, since Missing
No,
Autonomous,
no, not Mr. P. Sharma, Mr. S. Bhattakar.
they have not invited tender.
Have they invited any tender?
No, 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 no. They have straight away given settlement, my lord. That is my case, my lord, because this bill total, there are 5 bills.
Earlier cases are cases of jurisdiction.
My lord,
Earlier cases are cases of jurisdiction
yes, my lord,
where Missing Autonomous Council does not have it.
yes, my lord,
When there is a fishery which is already settled by them.
yes, my lord.
Now, in respect to Missing Autonomous Council, you are not debarred from participating.
Autonomous council, even if they invite tender, my lord, the question will boil down to again one thing, whether they have jurisdiction to issue NIT. Number one, my lord.
No, who are you to challenge?
Because I am one of the prospective bidders.
Prospective, you can very well bid.
So then that NIT, assuming there is an NIT, will be confining to only the people in and around missing council, my lord, areas and people who are within the council area. We are people of 100.
No.
That is not the case.
That is not the question. Therefore, I am saying
My
it.
lord.
It cannot be only for missing autonomous council.
No, Your Lordship. And it cannot.
That cannot be for missing autonomous council. They would be in violation of Article 19(1)(g). They may have some reservation. It's a different aspect of the matter, the another aspect of the matter. But if you want to participate, if they have issued a tender, you could have very well participated.
Exactly. That
In
can
the earlier cases, it has already been settled.
Correct.
It is a different case where they may say that missing autonomous council is doing it illegally.
Yes.
That is a different aspect of the matter.
Absolutely.
Which has nothing to do with you. So is it your case out here that they have granted this tender without following due process?
Yes, absolutely.
Where is the statement?
Earlier case, lordship, that learned code has prospective bidder also. When prospective bidder approach, then also stay was granted, lordship.
But that is not my opinion. The orders, the interim orders, we are not bound by that.
I don't know.
It's not binding. Is it binding?
May I take the lordship? Petition number 15, paragraph number 4 of my writ petition. May I read?
Yes.
The petitioners begs to state that in pursuant to the above orders passed by this honorable court in aforementioned to writ petitioners were under a bona fide belief and impression that the state respondents in terms of the said orders would take necessary steps for issuance of fresh NIT, and thereafter settle the fisheries, including the fishery in question, by following the due process of law. However, to the utter dismay of the writ petitioner, the respondents, more particularly 6 to 8, by clearly ignoring the mandate of the aforementioned orders passed in the earlier round of litigations, and also by ignoring the mandate of the relevant act, Missing Autonomous Council Act, and the Assam Fishery Rules, issued the communication settlement order. The writ petitioners herein are highly prejudiced and grossly aggrieved and grossly prejudiced by the imputed settlement order, in as much as, in spite of
Come to paragraph 5.
the petitioners were submitting a representation before the outcome of these petitions with bona fide impression and expectation that said respondents would comply with the directions of this court as contained in the aforementioned judgment and would initiate the process of settlement of fisheries in question by inviting tenders and following the due process of law, my lord. However, to the utter dismay of the petitioner respondents, without giving any due regard to observations and directions of this court, by ignoring the relevant provisions, are, my lord, by issuing NIT, my lord, have allowed the private respondent number herein to run and operate the fishery in question on an ad hoc basis.
Is it on ad hoc basis?
Yes, my lord, for 2 years. These fisheries will have to go for 7 years. These are 60% fisheries, my lord.
Notice making it returnable on 19/8/2024. Steps. Mr. S. Bhattakur, Mr. P. Sharma appears on behalf of the respondent number 1 to 5, 1 to 4. Mr. M. Chetty appears for respondent number 5. The S. Bhattakur appears for respondent number 6, 7, and 8. And Mr. Fusto. As the respondent numbers 1 to 8 are duly represented, extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 9, steps be taken by way of registered with AD as well as usual. So in addition to that, the petitioner is also directed to effect service by way of dusty related to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner is a prospective bidder to the, which one?
My lord, this fishery is called Brahmaputra Part 2, my lord. At serial number 2, my lord.
Brahmaputra Min Mahal Part 2. On the earlier occasions, the petitioner have approached this court on various occasions as regards the actions on the part of the fishery department of the government of Assam in settling the said fisheries on daily basis. and orders have been duly passed by this court. To settle the said the fishery in question by following due process. However, to the utter surprise of the petitioner, the missing autonomous council, that is the respondent number 6 to 8, without having authority or jurisdiction over the fishery in question, have settled the fishery for a period of 2 years, that is from 2024 to 2026, in favor of the private respondent, that too without inviting for any tender. The petitioner challenges the the settlement order dated 25/6/2024, primarily on 2 grounds. The first ground be, firstly, primarily on 2 grounds. First, the missing autonomous council has no authority or jurisdiction to exercise its authority over the fishery in question. Secondly, it is the case of the petitioner that even assuming the missing autonomous council has the authority or jurisdiction, then also the same cannot be done so without inviting tender or following a transparent procedure, which is the mandate of Article 14 of the Constitution. This court have duly heard Mr. S. Bottaku, the learned counsel, appearing on behalf of the respondent number 6 to 8, and inquired as to whether the fishery in question, which all along have been settled by the Fisheries Department of the Government of Assam, have been transferred by the Government of Assam to the missing autonomous council. He submits that he would like to take instructions on the said aspect of the matter. Mr. P. Sharma, learned counsel, appearing on behalf of the Fishery Department, submits that the missing autonomous council has no authority or jurisdiction over the said fishery in question, and it has all along been it is all along under the jurisdiction of the Fishery Department of the Government of Assam. He further submits that in pursuance to the orders which have been passed in the earlier petitions, the government are also planning to take appropriate actions for inviting bids.
Yes, sir. We have already issued orders.
Inviting
Daily
tenders.
basis has been withdrawn. Daily basis has been withdrawn.
No, that you have to. It has not been withdrawn. It has been set aside.
That is.
Oh,
Sorry, we
so
have.
I've already been taking steps for inviting tenders. Taking into account the above, this court prima facie is of the opinion that this is a fit case for stay of the impugned order dated 25/6/2024, more particularly in respect to Brahmaputra Mean Mohol Part 2 till the next date.
I'm highly obliged.
I could have stayed the entire order in once, then it would lose. Mr. H. Buragohai will lose for the other 3 fisheries.
I'm highly obliged.
Item 15.
Hey, Mr. M. Setia, kindly call Mr. B. Gogoi once, and someone call Mr. K.P. Pathak, please. Yes.
That is for non-payment of contractual.
What is this?
No, it's a construction.
On payment of dues.
Yes.
What does the Tiwa Council say? Who is appearing? Tiwa Autonomous Council, they don't have a standing council. Who?
S. Neogi is there today. Mr. S. Neogi is there today. Perhaps he didn't come.
His name has been shown in the cause list. It has been submitted at the bar that Mr. S. Neoge is the standing counsel of the, his name has been shown. Oh, that's okay. Heard Mr. So-and-so appearing on behalf of the petitioner. None appears on behalf of the respondents on call. This is the case. The instant writ petition has been filed by the petitioner being aggrieved by the actions of the part of the respondent authorities in not releasing the amount to which the petitioner claims to be entitled to for completing the work of construction of World Road with metalling from Bijoypur LPS to Rangmili. For perusal of the writ petition, it reveals that there are many orders I have passed in these type of matters.
Yes.
You have it?
Right now, I don't have it.
Lot of matters I have disposed of. From a perusal of the writ petition, it reveals that the president, that the respondent authorities have issued a work order for construction of the road with metalling from Bijoypur LPS to Rangmili, and the total value of the said work was rupees 10 lakhs. Out of the said amount, the petitioner was released an amount of rupees 6 lakhs. And the remaining amount was to be released subject to production of the MB vouchers, utilization certificate, completion certificate, and one photograph before the start of the scheme, and one photograph during the work, and one photograph after completion of the scheme with signboards duly signed by the president and the member secretary. The case of the petitioner is that pursuant to the works in question, pursuant to the work order issued, the petitioner have duly completed the work and the necessary documents in support thereof have been duly submitted. However, the respondent authorities have not paid the said amount. And it is under such circumstances the instant writ petition has been filed, challenging the actions of the respondent authorities to make payment of the said amount paid of the remaining amount of rupees 3,60,000. This court had duly taken note of that pursuant to the issuance of notice, the respondent authorities have not filed any affidavit in opposition denying to the allegations made in the writ petition. This court, upon hearing the learned counsel appearing on behalf of the petitioner, is of the opinion that the interest of justice would be met if a direction is issued upon the respondent authorities to make necessary verifications as regards the petitioner's entitlement on the basis of the materials which have already been submitted by the petitioner. And upon verifying, it is found that the petitioner is entitled to the said amount be released to the petitioner as expeditiously as possible and preferably within a period of 6 months from the date a certified copy of the instant order is served upon the respondent number 2. With the above, the petition stands disposed. Mr. Gogoi, you see, I'm still, I actually need to fix that matter on 24.
It should be 24.
24, and you filed that on 19th.
Yes.
Just 2 days. Only there's 3 documents or 4 documents
Yes.
now. Huh? Because otherwise the matter would get delayed.
Yes, madam. So I can file it, can it be by 22nd? Monday.
Why I'm saying they may not get the chance to
Yeah, I will
reply.
file.
Therefore, I have passed in the order, made it very short, concise.
Yes.
Only that.
Yes.
bring on record, because otherwise, if you don't bring on record that, it becomes difficult. Tomorrow, when an appeal is filed, it becomes difficult. I'll fix it. You have filed by 20,
I will file it by 19.
or you can file it by 22nd.
By 19, I will serve.
By 21st, you serve advance copy.
By 19, I will.
And
mail
you
it
file
to
it
them.
better. You file it by 19th.
Yes.
Huh? Or 28th. You can file because it's the third Saturday.
Yes.
Okay. You file it by 28th.
By 20th, I will file.
File it, and by 24th. You inform Mr. Pathak about that.
I have informed him.
Because there was some means I was while seeing this, it was making this thing.
I just inform him.
Okay, please inform.
Obliged.
16.
Like to withdraw this petition.
What? Oh. Mr. DJ Das, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated. Mr. D. Gogo appears on behalf of the respondent. Forest?
No, Assam Agriculture University. Assam Agriculture University.
The respondent, Assam Agriculture University.
17.
Yes.
The non-payment of bill, my lord, there is an admission at page 28, my lord.
Lahok, Mr. Heard, Mr. J.L. Bormuya, the learned counsel appearing on behalf of the petitioner. The instant writ petition has been filed by and Mr. D. Gogoi appearing on behalf of the PHE department. The instant writ petition has been filed being aggrieved by the inaction on the part of the respondent authorities in making payment of the dues to the petitioner to the tune of rupees 35,56,000. Along with interest. It is seen from the records that it is seen from a perusal of the petition that the petitioner was issued a work order, supply order, dated 8/10/2013 for supply of low-cost sanitary materials under Nirmal Bharat Abhigyan by supply order number PHE/CE/BE/NS/PB-38/2013-14/5879. It is the case of the petitioner that the petitioner had supplied in terms with the supply order and is entitled to an amount of rupees 35,56,000. However, in spite of various representations, the respondent authorities have not paid the said amount. Resultantly, the petitioner being aggrieved has approached this court. It is seen that this court had issued notice on 22/2023. However, there is no affidavit in opposition filed denying to the entitlement of the petitioner. This court, taking into account, having heard the learned counsel on behalf of the parties, and having heard, is of the opinion that the interest of justice would be met if a direction is issued to the respondent authorities to make necessary verifications and thereupon pay the said amount. This court directs the and make necessary verifications, and upon verifications, if it is found that the petitioner is entitled to, then to make such payment. This court therefore directs the petitioner to serve a certified copy of the instant order to the respondent number 2. Respondent number 2, who upon receipt of the said certified copy shall carry out necessary verification either by himself or through his delegate. And upon verification, if it is found that the petitioner is entitled to the said amount be released to the petitioner within how much? 8 months? 4 months. Very well. Sometimes I'm giving you 8, you want 4.
6 is too long, my lord. 6 is too long.
6 months, within 6 months.
Let it be 4, my lord.
4, no, 6 months. 6 months. From the date a certified copy of the instant order is served upon the petitioner. By the petitioner to the respondent number 2. With above the instant petition stands disposed. Yes. What is this on anything important?
Challenge to a demand notice being issued
Uh,
to us. In fact, right from the day when we took over possession of the fishery,
uh,
we were facing difficulties because the missing people were not allowing us to operate the fishery.
Hmm.
From the day onwards, we had written to the judicial authorities, the interim orders protecting us also. Now, my lord, the
There's
government.
no interim order.
We have protection, my lord.
What protection
Now,
you
the
have?
government has filed an affidavit supporting our case.
Very good.
If I invite my lords to the affidavit by the government fishery department,
Wait, let me know what is your case.
my case is.
Don't expect that I come reading after having read the file. I know only, yes, when you are going
My
to
lord,
see me. Yes, tell me.
10th of December,
Hmm.
2020,
You were settled with a
fishery.
fishery. Then what happened?
Department fishery,
You were handed over possession when?
10th of December.
5th of December.
10th of December. 10th of December. The next page.
10th of December,
10th
you
of
were handed over possession. Thereafter,
Thereafter, when we went to do the fishing and collect
for
revenue,
7 years.
seven-
Yeah. Then,
we had difficulties because the people of the missing community were not allowing us to operate. So we submitted representations to all the authorities, even naming the persons also. Now, apprehending that the risk loss would be invoked against us because it was 1 crore plus the settlement amount and 22 lakhs what we had to pay per year. So we wrote to the authorities, identifying the persons. Nothing was happening. We came to the court and the first order was that at page 50 that no coercive measures be taken against us. So far, so good.
that is the order of 15 to 2021.
21.
Then,
No coercive measures. Now, my lord, the demand, although this order was there, a demand notice was issued by the authorities for 9 lakhs something odd. And there was an order of status quo by this honorable court. Then page 56 order is quite relevant. Page 56.
yes, what does it say? Till then, the interim order passed
No,
earlier
not
shall
that,
remain
but-
in force.
The second paragraph at page 57.
Is the matter intending then?
So that the length and breadth and also to the boundaries following up the missing autonomous council. So give the entire length and breadth of the fishery and the length and breadth of the area, the boundaries which fall under missing autonomous council. So that was not happening.
Why is that everywhere the problem is because of the missing autonomous council? Why? They don't hear anything.
What happens is, since fisheries are settled by the government or by the AMTC or others transferred. Now, if it's a riverine fishery.
Where is the fishery department?
They are
Yeah,
supporting
fishery
us.
department is not here.
Yes, they supported us.
For that, he has gone.
The affidavit is supporting us.
Then,
Now what happens? Things in riverine fisheries, as the river flows, the jurisdictional areas overlap. A settlement is made by the government under the fishery rules. So, muscle power is often exercised by people knowing or not knowing is good or bad. And at times, without jurisdiction, unilaterally, settlement orders are issued by the Middle Autonomous Council. Those are being interfered with the court time and again, and orders are issued also. But this continues in a fashion because no concrete order is coming either way by the government or this side.
now what has happened?
Now what has happened is that this matter continued and the Honorable Court directed, give the length and breadth of both. This is not forthcoming. Eventually, my lord, they issued a notice again, last which is under challenge. Now,
Page 115.
115 minutes. Now, may I invite my lord's attention?
Total amount payable is 39 lakhs 23,998.
Then,
Then,
now, the stand of the government at page 83 of the writ petition would be relevant. I'm skipping the other part.
No, what is the affidavit? What do they say?
Affidavit. Paragraph 14. Because we've written to all the authorities on record that with regard to statements made in paragraph number 16, 17,
It would mean that I am allowing partly the entire petition without hearing the other side. Not possible. I would have allowed it. Here you are already enjoying a stay.
19.
Interim order to Malawi. Yes, what is this? Oh, 19, he wants an adjournment. Because, list the matter again. Yes, non-payment. WR. Forget about that. Petitioner counsel is also not present. So what? Huh? So we don't require him. We only require you. You tell me why you are not paying. Tell me. He wants 4,18,407. Verify and pay. He did not take time. I did not grant him time. Anyways, as the counsel for the petitioner is not represented, matter be listed after 4 weeks. Huh?
Non-payment of
15 lakhs. Yes. Now,
the liability list lordship, they have admitted this amount lordship. They have admitted this amount in liability list lordship.
where is the deputy commissioner?
Issued by lordship, not deputy.
Oh. Understood. The paying authority is deputy commissioner, but the thing is, who issued the notice? Work order. Why did you issue? If you don't, you get the money from the deputy commissioner. How you get it? That is your lookout. We are not concerned. There is none of the documents which shows that. Is there any document by which the deputy commissioner is there? No, you can't bring the deputy commissioner out here. You ask the deputy commissioner to pay. Which deputy commissioner is this? Dubri? Oh, sees his office. This is office. Don't work. Get your payment done. I hope. Nothing doing. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Yes. So, if you have done the work, why have you mentioned anywhere in your work order that this is done at the behest of the deputy commissioner? No. What affidavit? You have not filed it till now. Subject to interest payment by you. Interest. Nothing doing. You can't bring the deputy commissioner like this. Your order does not show anything about the deputy commissioner. Where is it? What? Immediate measurement to protect RNB of Boraguri, lengthening embankment at so and so. Why will the deputy commissioner pay for embankment? You have CRF or whatever scheme, that is your lookout. You have not made even a copy to the deputy commissioner also. Nothing doing. You get hold of a deputy commissioner, get hold of whatever money. Okay. List the matter again on 29th of July 2024, on which date the learned counsel appearing on behalf of the Water Resource Department shall ensure details are being furnished as to whether the petitioner is entitled to the said amount claimed. Pass the order. Yes, what is that? None appears on behalf of the petitioner on call. List the matter for 4 weeks.
Worship, I'm appearing in item number 2. Respondent government filed an affidavit on 24/5, but that copy was not supplied to us.
Who filed?
Item
You
number
filed.
20.
You have not served a copy?
Yeah. But the copy,
23. It has been submitted at the bar by the respondent counsel to the effect by the respondent government that a joint affidavit has been filed in petition number 2056/2023. Full stop. The counsel appearing on behalf of the petitioner in WPC number 2172/2021 submits that she may be provided a copy so that she may make appropriate submissions, or if so advised, may file a reply. List the matter after 4 weeks. In the meantime, the counsel appearing on behalf of the state shall supply a copy to the petitioner, and the petitioner would be at liberty to file the reply. 4 weeks, dated the DDBO, 28th of August.
The respondent number 3 filed an affidavit.
What is this?
Lordship, non-payment of bill, but during the pendency of the repetition, they have paid some amount of money. But
How much?
Lordship, they have paid 17,79,589.
You have got it?
We have got, but certain portion of amount.
Oh, these are interest, the tax deduction will be there.
Despite that, they have themselves stated in their affidavit.
What do they say?
Lordship, paragraph 8, Lordship.
Has paid the remaining amount of rupees 18,53,000 by the order dated so and so. Bajrang so and so invoice is not found. Amount bill is in hence same could not be processed if the petitioner firm submits the EIE man. Then
And that
of the
annexure
payments
one,
made
Lordship,
is
that
as
could be
follows.
there.
How many is the amount? Only 24,000.
So there will be more amount, Lordship. They have miscalculated. They have miscalculated, Lordship.
What miscalculated?
Lordship, para 7 is indicated.
7 is what?
Para
Yes.
7, they have said that they have paid an amount of rupees 18,53,738. But they annex the list in para page 45, Lordship. I have calculated. Item number 3, Lordship. 26/7/2023. That amounts come, Lordship, 18,11,605, Lordship, instead of 18,53,738. And moreover, Lordship,
You file your reply.
we will type, Lordship.
File a reply.
And
The counsel appearing on behalf of the petitioner submits that the affidavit in opposition so filed provides certain, gives certain incorrect calculation of the amounts to which the petitioner is entitled to. Accordingly, he submits that 4 weeks' time may be granted to file the reply. List the matter again on 2nd of September 2024. The petitioner would be at liberty to file the reply.
Moreover, they have stated that one annexure is there, Lordship.
File a reply.
This matter
Yes.
relates to the removal of name of pharmacist from pharmacy council.
What pharmacy council is this?
This from pharmacy council.
Cancellation of pharmacy notice.
This pharmacist license, well, these names are removed. Then they approach.
32B.
Yes.
Okay. Please the matter before any other court.
I'm legal.
Yes, Mr. BP Bora.
This matter
What is this?
is filed because I was selected in a draw of lots under Group 1. Thereafter, I was considered under group 3, I was selected in group 3.
Group
After
3 also.
Group 3, what is the browser says that the applicants, if there is no applicants in group 1 and 2, those applicants would be considered under group 3. Therefore, I was selected under group 3 also, and I submitted all documents also. Thereafter, the lease deed, I submitted notarized it, but they
need it for 19 years.
19
They needed it for 19 years.
Thereafter, there is a provision that it is a rectifiable defect within 21 days. I have to rectify. Within 21 days, I rectified. On 5th July, they intimated me that you rectify this. On 20 July, I rectified it. After that, they have rejected my case, saying that your date of registration is later than your date of application. That is challenge in this petition.
Where is the clause that you can rectify later on?
Yes. Page. Lordship, I'll just place 41 first.
No, Mr. Bora, I know what is group 1, group 2, group 3. It is not necessary.
Yes.
Only thing is group page 41, one thing is very relevant is the lower portion. In case land offered by the applicants in group 1 and found is not suitable, not meeting the requirement, then these applicants are the group 1 and along shall be in group 3 and would be advised by the OMC to provide suitable land in the advertised location within a period of 3 months from the date of issue of intimation letter to them through SMS and email. In case the applicant fails to provide suitable land within the prescribed period or the land provided is found not meeting the laid down right, the application would be rejected. Then?
Yes, page 46. This one.
Yes.
In case after selection, if it is observed that the offered clause 5, in case after selection, if it is observed that the offered land does not contain sublease as required by the OMC for CFC-CC sites, the selector would be given 21 days to make suitable amendment, addendum of the lease agreement, failing which the selection of the will be rejected and the candidate will be considered under group 3.
No, this is for the group 1.
Group 1, not even.
These are no relevant. That is why I'm saying.
59 also. Page 59.
No. You kindly come to, why don't you come to this clause at page 41?
41. Yes,
41, that clause I think will help you.
Yes. 41 I wanted to show.
Now, when did you submit? When you were intimated, did you submit the corrected copy within 3 months from the date of intimation?
Yes,
so why don't you make that argument?
Yes, Lordship. Page 87 is my date of intimation, Lordship.
Make that submission.
Yes.
You have a case on that,
Yes.
no? 87, application for remand is here, so and subject informing you the visit of land and so. This is under category 3?
Yes, Lordship.
How do you know? Group 3. However, your candidature may be considered for selection along with group 3. This is 1. This is 1. Where is group 3?
Page 90,
This is group 1. Where is group 3?
Yes, Lordship. Thereafter, at page 89,
I
have been previously selected under group 3.
Informing the drop lots for selection of the Iman and Iman in the venue of the so you have been declared as selected. This is a preliminary Iman award or subject to modification. This is of 10th of Iman. This is both the same.
Yes, and
where is it that you have been rejected and now relegated to group 3?
Page 119 and 120.
119. 119. Please refer. You are requested to submit the following details to close work by Iman to our office. Mention land documents in for long-term leave. Please note that your candidature is liable to be rejected. You fall. So
this is on 5th.
You are requested. No. When is that you have been intimated that you have you are group 3?
Yes, page 87.
That is group 1.
No, Lordship, page 87, Lordship will kindly have it.
Kindly see page 87, the last paragraph. You have not read it,
No, in
Mr.
view
Bora.
of the above, we regret to inform that your candidature is found ineligible. However, your candidature.
So that
may
is why this comes under group 1. If you fail to produce your documents properly, then you will be relegated to group 3.
Group three.
Because group 1 is for those people who submit those documents, who submits their own land.
Yes.
Group 2 are where there is a proper, there's already a memorandum of understanding.
Yes.
Group 3 are those who don't have anything, but within 3 months they have to get it.
Yes.
Now, is it your case that you were brought into group 3?
Yes, I was brought into group 3.
So where is it? That is why I'm saying. Anyways, prepare yourself properly. Otherwise, you had a good case. Least the matter after 4 weeks.
And Lordship, they have filed an affidavit. I can file my reply also.
Fantastic. Mr. BP Bora submits that he would file a reply to the affidavit in opposition for already filed by the department, by the Indian Oil,
Indian Oil Marketing.
by the respondent Indian Oil Corporation. Interim order is there?
No subject to outcome. No interim.
No interim order. Okay. These matters can be finished up one day itself. 5 minutes business. Okay, list the matter. We do one thing. We fix it on 21st of August.
Yes. Deep level.
Let's fix it on 21st of August. List on here. In the meantime, the petitioner would be at liberty to file a reply.
Deep level.
On that day, you prepare yourself properly to finish. What is this?
Okay, 1 lakh, my lord.
Got it? It has been inquired by the LR staff and it Concor Roy or his legal heir under the Ramakrishna. Huh? What is this matter for? No, why you are coming up with this type of instruction? Whether he's entitled to the amount or not. He may not be found. Whether these documents exist, find out. It is seen Mr. M. Setia appearing on behalf of the respondent has produced an instruction which, in the opinion of this court, has no relevance, taking into account that the issue involved in the instant case is as to whether the petitioner is entitled to an amount of rupees 1 lakh on account of restoration of the Bajarghat Nagendra Nagar Road under SDRF for 2018-19 under the Karimganj Rural Road Division. Mr. M. Setia submits that he will obtain the necessary instructions in that regard. To establish the matter again on 12th of August 2024. In the meantime, that said instructions be obtained. Mr. D. Gogoi, the learned counsel appearing on behalf of Forest Department, submits that certain additional informations have come to light which he wants to bring on by way of an affidavit. He therefore seeks for 3 weeks' time in that regard. List the matter again on 28th of August 2024. The affidavit be filed, additional affidavit. The additional affidavit be filed by 21st of August 2024. The petitioner, if so advised, would be at liberty to file a reply. Yes, Mr. Sahu.
Lord, against the order of the selection of contractor,
Huh?
housekeeping services. Against the selection of contractor, my lord.
Contractor?
Yeah.
Yes, what has happened?
Housekeeping services,
What service?
housekeeping services.
Why is it matter was before the division bench?
No, actually, we prepared appeal for interim order.
Then,
That was refused.
then what is left? Now, what do you want?
They were supposed to file an additional affidavit.
Of mandamus of Fishery should not be issued to setting aside the publication of evaluation report issued by respondent number 2, whereby the respondent authority ranked respondent number 6 as H1 in the contract bidding process. Alt of the AR. What is your marks? Why are two counsels here? Oh, you are a private respondent. You got more marks. Each one. Who is DB Enterprise? What is your name?
My name is BVG.
Who is? You are MJ Solanki. After MJ Solanki, there is one DB Enterprise. After DB Enterprise, there is one Goswami Security Service. After that, there is one Service Master Clean Limited. Then you come.
Because I am the only valid bidder. This is my also. I am the only valid bidder.
So you have challenged the validity of the technical response of the others. You have, both of you have filed the affidavits. So there is no denial to the fact that these are the marks they have got. Are you challenging these marks? No.
Very manipulation. My case is that there is a scope of manipulation. Because my lord, at page 28.
Anyways, okay, we do one thing. Ms. Again, the learned counsel appearing on behalf of the Union of India. Union submits that she would like to bring on record the publication of the evaluation report dated 22/9/2020 by way of an additional affidavit. List the matter again on. You want an early disposal?
Yes.
Matter again on 28/2024. 08/2020. In the meantime, the reply may be additional affidavit be filed by 9th of August 2024. The petitioner, if so advised, would be at liberty to file a reply to the said edition.
Please, Your Honor, I deeply apologize. In item number 23, I was on leg in another court. The CPI had to leave because his son was ill. I was there in the court number 24, so I could not appear in item number 20.
What order did you pass?
It's after 4 weeks.
Oh, 4 weeks.
A fishery is running over my patta land. There is some urgency, Your Honor.
Huh?
A fishery is running over my patta land. There is some urgency. Can it be of 2 weeks? After 2 weeks?
I'm fixing all matters after 4 weeks and you want this matter after 2 weeks. No. That too after not appearing. Fantastic.
Thank you.
Yeah, what is this?
Please, Your Lord. My lord, my license of petitioner writer has been cancelled without issuing a notice.
Huh?
So explanation.
For what? What license?
Writer
Petition writer license. Who cancelled it?
respondent number 2.
Where is that order? 8/3/2024. Peruse the reports received from the circular officer regarding cancellation of the petitioner's written license so and so, who is working as a petition writer under so and recently got arrested by locking and registered as so and so. The license of so and so is hereby cancelled within considering the fact of official regulation. Now what has happened?
I am without work.
What does the petition writer do?
He has a license to help in the office of the circle officer Lokipur in writing petition lordship to different litigants.
Okay. So you must have been suspended? No.
No, sir, not suspended. I am directly cancelled. The license is cancelled on the basis of an FIR filed by
Where is your terms of appointment?
Lordship 15 is the license, page 15.
The allow is an inhabitant of so and so is hereby allowed to work as petitioner in the office premises of the circle of the remand for a period of 1 year with effect on subject to annual renewal in subsequent years. Then 1 year is over.
Is renewed, subject to renewal, renewed lordship. Lordship, you can see page 15 down below lordship. Renewed up to 5/2/2025.
Okay.
Left side down below. Lordship.
When did he renew it?
But it is valid up to 5/2/2025.
When did he renew it? Huh? When was it renewed?
It was renewed after expiry the earlier term 5/2/2024.
Yes, you file your affidavit. Okay, Mr. So-and-so, the counsel appearing on behalf of the respondent states, submits that the affidavit has been filed. However, the same is not on record. List the matter again on 14th of August 2024. In the meantime, the petitioner would be at liberty to file the reply.
Lordship may kindly state impugned order, Lordship. On the first day, Lordship, the respondent was directed to file affidavit, Lordship. On the next day, they again obtained time 10 days.
You want to file a reply? Okay, we have it on 2nd of August. On 2nd of August, you file your reply. You have got a copy of the affidavit?
At 10, 11,
Okay.
30.
You file your reply, we'll dispose it of.
Obliged. Oh, and 30.
Yeah.
In this case, we have challenged the clause 10 of the NIT issued by the
You are IOCL council?
oil,
Are you an Oil India? Okay.
IOCL AOD Lordship.
IOCL, no.
Marketing.
There are some IOCL matters, nobody is appearing anyway.
Lordship,
Yes, what are these two matters?
in this case, Lordship, we have challenged the clause 10 of the NIT, which provides 3 days additional time to the highest bidder to cure their defects. Lordship. In this case, initially stay order was offered. Now the government has come up with a direction to cancel all the NIT. Lordship.
NIT is for what?
All the
NIT is for?
for in this case, hard ghat minimum also.
Oh, that NITs, they have cancelled it. Because now they want to have that 10%. That is what the reason why. They want to put a particular 10%, fixing up 10%. Then you have you challenged this? Okay, Mr.
I am
K.
put
Kolita.
item number 33.
J. Kolita?
K. Kolita.
J.
K. Kolita.
K. Kolita.
32, Lordship, MS2.
Is for 30.
Submits that the instant writ petition has become, both the writ petitions have become infructuous, taking into account that the present government's decision to dated 29/6/2024, whereby there was whereby the government whereby the principal secretary to the government of Assam Panchayat and Rural Development Department have directed that to cancel the ongoing process of settlement of ghats, fisheries, ponds, etc. for the year 2024-25 and thereby to include a provision in the tender document that the bidder who quote more than 10% of the average settled value of the last 3 years of the huts, fisheries, pounds, etc., shall not be qualified. Taking into account the above, both the writ petition stands closed as it has becoming infructuous. Interim orders, if any, stands vacated.
34.
Same matter, my lord. It's maybe.
Same?
Also becoming infructuous, your lordship.
Same. Itu belek ke hobo. Huh?
Oblige, lordship.
Yes, what is this?
So writ petition, we have challenged the tender clause at page 27, which says that, bidder should not have been blacklisted or debarred at any point of time.
What?
Bidder should not have been blacklisted or debarred at any point of time. I was blacklisted in 2012, 15th October, by the IIT Guwahati. I am even having contracts with them. But this clause offends the very purpose. The punishment is over. They can't have a blanket blacklisting forever. So having an interim order, they have to produce the stuff.
Now, which term you are against?
7. 23.8.
Should not have been blacklisted or debarred at any point of time by any central or human undertaking to be submitted from the bidder.
At any point of time is valid. During the operational period, I understand, or at least say last 4 years, 5 years, they may have a choice, fair choice. But at any point of
How many years you are?
12 to 15 is over. My blacklisting period is over. We have, my lord, may I clarify that? Page 5, paragraph 4, that the petitioner
So
was
where
not-
is the judgment of the Supreme Court which says that blacklisting is like a debt? What debt? Civil debt.
civil, we had the judgment on the earlier date, which says during the operational
Oh,
period.
so you expect this court
No,
should
I-
not look into any judgments and
No, we had.
pass order. What are you going to do if they raise that project? Tell me. We're saying that if the people raise that objection, what are you going to do? Are you going to change it? No, you give an undertaking, you are going to change it, we dispose it of. You tell me. Put it on affidavit. You are going to change it if it submits a representation. Fantastic. Good for both.
Should be submitted, but not through the portal. I concede.
Huh?
I concede. We did submit the representation, but not through the portal.
You submit it through the portal, they will consider. Then now that means that submission doesn't hold good now. Does it? The bid is closed. Why did you file at the last moment?
We had submitted the representation. No response was forthcoming. Now there are two views of it. Correctly against me also. I did not submit to the portal. Rightly or wrong, but I apprised them. Now, had I submitted in point of time, then they would have reacted to
You
it
have filed your affidavit.
from the clause itself.
You file your affidavit. I think this is a matter to be disposed of as early because there is a technical decision has been stalled. You file. Mr. Mr. Christie, the learned counsel, appearing on behalf of the respondents, submits that he is going to file his affidavit by 26th of July 2024. So taking into account that there is a stay order operating, which is affecting the respondents, this court fixes the matter on 1st of August 2024, on which date an attempt shall be made to dispose of the matter in the, you file by 25th. File by 25th. The petitioner would be at liberty to file their reply by 31st of July. Interim order passed earlier shall continue till then. Yes. What are these two matters? Okay. Hmm. Then, now if the contract has been terminated, is there no arbitration clause?
Arbitration clause, what I
What is the contract for?
running food and beverage service and housekeeping also in the IOC guest house. At 690.
Because certain things, unless it is prima facie, it becomes very difficult for the court.
My lord, specific arguments of the contract. My lord, in this case, my lord, the documents are sufficient, my lord.
Okay. Interesting. Will you have it on a particular date? You suggest a date? 30th would be difficult.
My lord, the contract was for May 23 to April 25. 1 year is gone like this in litigation, my lord. So, my lord, we are seeking an early hearing.
Huh?
We are seeking an early hearing. Because the 1 year
Early hearing is okay, but the thing is like this. 30th would not be possible because for me, I will have some difficulties if I am taking up the matter. Let's have it on. Let us have it on 1st of August. Here I have some percentage. Provided I'm taking up the bench. List the matter, taking into account the matter would require an early disposal, and the counsel appearing on behalf of the petitioner had expressed urgency. List the matter on 1st of August 2024, on which date an attempt shall be made to dispose of the matter. Liberty is given to the parties to mention the matter for upgrading.
Right.
Complied? Complied? Who is to comply? Huh? PWD. You are BTC. Huh? On behalf of PWD. What is that order passed? Let's see. Payment as per Tamsir Ali. No, time frame would not be there, but are you acting in terms with Tamsir Ali or not? That's the question. Find it out whether the petitioner is there in the name of the list. So matter over. Okay, the counsel is appearing on behalf of the respondents shall obtain instruction and if necessary file the affidavit as to whether the petitioner's case have been duly considered, taken into consideration in terms with the judgment of the full bench in the case of Tamser Ali and others versus State of Assam reported in 2008 4 GLT page 1. List the matter again on 7th of August 2024. Just find out that. It won't take much time.
Alright.
Same. Well, why? Tamser Ali. What is this? Oh,
They verified and find out the name, officers and title. They file their affidavit also.
oh. You are filing cases, na? Suits in these matters? Huh? What is your instruction? Have you filed your affidavit? What is your stand? Upon verification, what did you find out? There is no sufficient funds available in disbursing and the only. No, madam. Huh? Yes. No, there are some suits also filed. There are many other allegations against these matters. But your affidavit says otherwise. Filed a complaint for non-payment of the so-and-so and it is found, and as per the contempt petition is found to be entitled to so-and-so. Mention and worthy that out of the total of so-and-so release demand to the contempt petitioner, which is admitted by the contempt in the contempt petition. However, on the basis of the information furnished by the VTC authority, there is no sufficient fund available for disbursement of so-and-so. What to do? How many persons are parties here?
On the principals.
Huh? What? You have to release. You have already verified. Say that. But that is not your stand in your affidavit. You said you don't have money, so you're not paying it. Mr. Dinath, you remember those matters? Once what happened, there was a lot of other matters which are also pending pertaining to these type of litigations, where there was one order passed by the BTC, and because of that, there were Mr. R.K. P.K. Musari is another counsel, na? R.K. Musari, huh? So there was a matter pending. There are a lot of matters whereby this court has disposed of in view of a decision being taken by the BTC that we are going to make the verification and make the payment within a period of 6 months. And it is on that basis there are many orders have been passed by this court. Later on, it was found by the CM Vigilance that there are a lot of misappropriation cases which has happened. There was no work, nothing has been done and all these things. Be that as it may, many suits have also been filed out here. And where they were filing written statements out here, initially the written statements were not filed properly and all. These are matters of which is going on. Here, if you are admitting out here in this manner, madam, you have a problem. This amounts to non-compliance. And this order, if we are directing for compliance, it will affect a huge lot of litigations. Remember that. I'm posting this matter after a few days because that matter, the Advocate General appeared. You inquire with him and tell him about that. Because this any order passed out here, and the stand which he has taken, that he says that 10 lakhs we have already paid to the petitioner and 21 lakhs is to be paid. And this admission will have far-reaching consequences in all the other litigations.
Also verified and found.
Huh? Understood. This is the problem which has happened. Because then there is a matter which has been placed before the CM vigilance. Because that matter also I took up when I was taking a bench 4, bench 5, 4 months back. So then when it was placed before the CM vigilance, they found that there was a large case of corruption and all these things. There were nothing done and nothing done, and this is the allegations with. Now, if this is the stand being taken by the principal secretary, can he tomorrow, can the principal secretary there say anything else in respect to which is going on? Let's on this matter, just take a call with the Advocate General. This is the matter again on of August 2024, on which state Ms. R.B. Bora shall obtain necessary instructions as to the contents of paragraph 5 of the affidavit in opposition of the respondents. I'm fixing it. You just inform the Advocate General because this matter, I think he and I think Rajiv Borpujari is doing it. Same. Is it same? Same matter? Oh no, this is different. Why you have not been able to pay? Is this the same matter? No, this is a different matter.
That's to be verified.
Yes, this is the matter. This is the contractual bills. Same order. Why? How can you withdraw something which has come on record? My goodness. Did you ever heard of? Can you withdraw? You can't withdraw, somebody has filed something. Once in not press. Anyways, this is the matter again on 12th. I got to give an asset. 14. R.B. Bora shall obtain instruction. 41. You can hear it. What is this matter? And Finance Department. Release the balance.
Case number 44, Your Lordship, relevant provision.
Then when are you paying? How long? Mr. Dean, the learned counsel appearing on behalf of the. You have already stated in 21(6) the same thing. The Dean, the learned counsel appearing on behalf of that the finance department has already been moved, and it is likely that the said amount will be the 6 for time for that. It's the matter on 21st of August 2024. On the same date, the counsel appearing on behalf of the respondents shall update this court as to whether the payment has already been disbursed to the petition.
Oblige, your lordship.
Ardhor. Yes, what is this? Non-payment. What has happened? When are you paying? You are on the verge of?
Almost 30 crore. So between these cases, we have 13 crore and 115 my lord, the rest 17.
Oh, I passed something similar order earlier.
My lord, this is the two my lord ceiling 115 my lord. We got not only there, some other cases my lord. Where what was passed?
How much time?
Date is there, my lord.
Very well. Mr. Ardhor, the learned counsel, appearing on behalf of the petitioner, submits that a financial sanction has been received. Financial sanction has been received on 15/7/2024. And as the ceiling is valid up to 30/7/2024, the petitioner is likely to receive prior to that. List the matter again on 7th of August 2024, on which date the counsel for the respondent shall update as regards the status of the payment as to whether the payment has already been disbursed to the petitioner. Same. 45 also same. So many contempts. Seems people are not listening in. Yes, when are you paying? Mr. Dinath, the learned counsel, appearing on behalf of the respondent, submits that the petitioner is likely to get the amount within a week. List the matter again on 7th of August 2024, on which the learned counsel for appearing for the respondent shall update as to whether the petitioner have received the amount. Okay. Give it. Last.
This matter service with respect to respondent number 1, 3, and 4 has not.
What is this matter about?
Lordship, matter pertains to settlement of Sen Mahal, Lordship. By order dated 8/5/2023, the impugned order dated 15/3 was set aside and quashed, and the respondents were directed to take a final decision. The petitioner's application dated 31/2023 to surrender the
Who?
Sen Mahal.
Who was to take the final decision?
Lordship, the forest, Lordship.
Forest, yes. Why you are not taking the decision? Secretary has been asked to take a decision when? Huh? Respondent state shall take a final decision with regard to the petitioner's application for surrendering the Borpani sand permit, so and so. Okay? Why you are not taking the decision? So what? Contempt for punishing other things. Otherwise, department. When? Next week. Mr. D. Gogoi, appearing on behalf of the Forest Department, submits that he would take instructions as to when the the respondents shall take a final decision. When is this order passed? 8/5. My goodness. And shall take instruction as to whether the state respondents, more particularly the secretary to the government of Assam, secretary to the government of Assam Forest Department, have already taken any decision over the petitioner's application dated 31/2023 for surrendering the Borapani Sand Permit Area number 1 bracket capital B. Full stop. List the matter again on 31st of July 2000, no, not 31st, 24th of July 2021. Whose name? Your name is not there. Why are you appearing? Oh, very well. The registration show the name of Mr. D. Gogoi appearing on behalf of being the standing, showing the name of Mr. D. Gogoi, standing counsel of the Forest Department in the causeless. Because you see, for the purpose of affecting compliance, departmental counsel can be affected. For the purpose of punishment, then he has to be heard. I'm here nothing to do with now for punishment. It is how you comply with. Once it is being complied, if it is can be complied with, very well and fine. Why should we go into all these things? Because you see, one has also to take note of engaging every time you are engaging a counsel, because the person is done in person. He may not have the resources for appointing a counsel every time. Because a private for a contempt is a private matter, so he may not have the resources. So yes, if he has committed the contempt, then obviously he may have to engage some. If that is a view taken, then the officials are also taken care of properly. Otherwise, officials will have a hard time every time to appear. Engaging every time a senior counsel, it becomes very difficult.